Tell me about that picture.
And that's me.
That's you?
And that's Raya.
And that's Jeremiah?
And that's King.
And that's what?
That's the controller.
That's a controller for game, okay. Where are you in that picture?
This is the trial of Patricia Kelley, a grandmother accused of physically abusing her grandson. You will hear the forensic interview, testimony from the forensic interviewer, and even testimony from the grandmother. Before that trial begins, there is a quick hearing on a man accused of another kind of abuse. If you wish to skip ahead to the trial, it starts at 17:16.
Would have been sufficient for the court to revoke bond, as some of these offenses are bond on bond. Case 2020-192, which happened June 28th of 2020, there was originally a $10,000 bond. And then in 2020 CR 351, those offenses, charge of rape, occurred July 4th of 2020. He was given a $50,000 bond. While out on the $10,000 and the $50,000 bond, he was then charged in 2021 CR 59 with vandalism occurring on December 1st of 2020, was given another $50,000 bond, which he made. While out on $110,000 bond on the 3 cases aggregate, he was then charged with aggravated burglary and rape occurring June the 6th of 2021, and was again released on another $50,000 bond. So at the point that I filed this bond motion, he had an aggregate bond on the Dixon County cases of $160,000. Judge, I would like to bring to the court's attention that the defendant has previously been convicted of FTA. I have certified copies of that, which the defense has had an opportunity to review. That conviction was in 2018 and was from an offense in 2017. Additionally, while not included in my original bond motion, while out on bond, the defendant was convicted of multiple offenses in general sessions and served an 1129 sentence. So there are offenses from June 18th of 2021, where the defendant was convicted of false imprisonment and was given 1129 to serve. That conviction was on 7/7 of 2021. He was also convicted of reckless endangerment to run concurrently. I'll pass those up. Those are certified copies from Ms. Shelton.
Just have them marked along with this one, if you will. Officer, if you'll turn your microphone on there, sir.
I'd like to, before those are entered as evidence, reserve objections to those, but I wanted to allow Ms. Bryson just to present with her argument. I think it'll make this move faster.
We're going to mark them, and whether or not they are admitted as evidence or not, I will consider your argument at that point.
Thank you.
Okay. I have another conviction from offenses on July 31st of 2020, where Mr. Godwin was also convicted that same day, July the 7th of 2021, and pled to criminal trespass. That sentence also ran concurrently, as well as assault, simple assault. Those are also certified copies. Judge, this case was continued because the state late filed a notice of impeachment and range of punishment, and I'd like the judge to consider the defendant's criminal history when determining, should you reinstate a bond? Should it be the same bond, or is that bond high enough considering the fact that he continues to get new offenses and has shown himself through his criminal convictions to be a danger to the public? Judge, his criminal history, most of those offenses start in 2007, and he has been convicted of robbery, aggravated burglary, another robbery, aggravated kidnapping, theft of property, especially aggravated burglary, another aggravated robbery, another aggravated kidnapping, and carjacking. And so we have a man with a demonstrated history of being a danger to the public, who has 4 stacked up cases right now trying to be tried in front of this court, who continues while he's on bond to commit new offenses. Should the court choose to reinstate the bond because of the state's late filed notice, it is abundantly clear that $160,000 is just not sufficient. And so I would ask the judge to set a bond commensurate with the danger to the public.
Mr. Spratt, you wish to respond?
Yes, sir. Your Honor, as the court is well aware, this hearing was held in February, and the evidence solely put before the court at the Bergens hearing was the Lawrence County conviction. Or, I'm sorry, the Lawrence County charge. That suppression motion, my understanding is that the suppression was filed before the officer passed. The officer did pass, but there were identity problems as to whether or not that actually was Mr. Godwin. Those issues never got to be argued. As I said yesterday, we did not have the opportunity for cross-examination at the court's Bergens hearing in February. With respect to some of these cases were direct presentments, so I don't know the bond order. But the problem I've got with all of this is we're re-arguing things that, again, this procedure runs afoul of the due process considerations in Bergens. He's not got to cross-examine a witness yet, period, in any of this. And now the state presented evidence to the court over objection that we won't get to cross-examine ever. And now they're coming back and trying to re-argue. I understand what Ms. Bryson is saying, but with respect to those Sessions convictions that she just put up there, the reason I walked in a couple of minutes late yesterday is because I was on the phone with Mr. Miller, retired General Miller, because I'm not sure that we didn't enter those agreements. I don't recall, General Miller didn't recall, former General Miller, whether those were, as part of that, it was in lieu of a bond revocation. So I don't know. Add to that, I didn't know that we were going to get into all this stuff until 1:30 yesterday. I did not. Now, I don't know about that failure to appear, but I have not reviewed the conviction. I don't think General Bryson, I may have run through it. I was trying to run through this as quick as I could yesterday before I got out here, but that's not noticed, and it wasn't argued at the original hearing. So to come in and there's nothing sworn here other than things that has already happened. He did his time for those Sessions cases. The first 2 cases that are still before the court, I don't think those were bond on bond. They were presented, investigated, and directly presented at the same time, including the case that I'm asking to reinstate the bond on, which I would also add is the only case before the court. That's the case that the bond was revoked on. That's the case where I'm asking to have it reinstated. Mr. Godwin, as I said, has a newborn child. He'd be willing to yield to an ankle monitor or any other conditions that the court may impose. As I said, he has stayed in touch with me throughout the pendency of the case. He's not been proven a flight risk whatsoever. And I don't know if the court, General Bryson and I are more or less up here making arguments. And so, as I've argued before, the Bergens decision entitles you to cross-examination. And had that officer been here, I don't know that he could have identified Mr. Godwin in that case. It was a motorcycle that I don't think he could identify who it was on the motorcycle. So while some of these things that she mentioned were listed in the motion, they were never argued. He's never been able to cross-examine any of it. So, and I believe that maybe they did think this was going to go to trial when General Miller and I entered those convictions, but they didn't. And then a late filed notice of enhancement comes. This is not his. He carries the presumption of innocence on these cases that he's charged with. And I think he's entitled to bond. I don't think there's been a request in writing for the state to increase the bond, but he would yield to an ankle monitor. It would be no problem. So we're just asking that, and with respect to boobies, if they won't go back on the bond if they've been exonerated, the $10,000 bond would be fine. I could contact Ms. Sessler and see if she'd be willing to do that. But he would yield to any conditions. And if the court wants to hear testimony, we can do that. I mean, that's the reason I tried to reserve my objections so we can do this quickly. But I would object to the things that she entered as the court being entered as evidence. One, we weren't given those. I had no idea that was going to be argued until yesterday at 1:30. So I object to them trying to go back and relitigate issues that weren't litigated at the prior hearing. Res judicata is one issue, and then the procedural due process violations.
All right, first and foremost, I would point out the following, and that is that the state's motion to revoke bond, which was filed February the 12th, 2024, was citing 4011-141, subsection B, and that statute says the following. If after the defendant is released upon personal recognizance, an unsecured personal appearance bond, or any other bond approved by the court, the defendant violates a condition of release, is charged with an offense committed during the defendant's release, or engages in conduct which results in obstruction of the orderly and expeditious progress of the trial or other proceeding, then the court may revoke and terminate the defendant's bond and order the defendant held without bail pending trial or without release during trial. That is the statute upon which the original motion was filed. I would simply point out it does not require that the defendant be convicted of an offense. It says where the defendant is charged with an offense committed during the defendant's release. So looking at the state's original motion to revoke, in this court's opinion, my opinion was not based solely on one conviction or one charge in Lawrence County. That was the most minor of all of the charges, in my opinion. The state's motion to revoke cites that he was originally, in this case that we're dealing with, charged with sexual battery and vandalism. Those happened on June 28, 2020. He was released on a $10,000 bond. While out on bond for that case, he was charged with rape that occurred on July 4th, 2020. That was after the date of that first case when he was released on bond. While out on bond for those two cases, he was charged in another case with vandalism that occurred on December the 1st, 2020, and that was a $50,000 bond. While out on bond for those three cases, he was charged with aggravated burglary and rape. Those offenses occurred on or about June 6, 2021. Again, he was released on $50,000 bond. While out on those cases, he was charged in Lawrence County and with driving on a suspended license, reckless endangerment, evading arrest. All of those were considered by this court in the original order revoking his bond in this particular case. The Lawrence County case may have been dismissed, but the reason it was dismissed, according to this court's review of the information, was because of the fact that the defendant, the defendant moved to suppress the evidence, and the court could not conduct an evidentiary hearing because the officer was, at that time, was deceased. So this court, in considering any bail motion, is not just required to consider the required to consider the charge itself, but is required to consider all of the factors that are set forth in 4011-118. And those factors set forth a number of different things, but one of the most significant is that the defendant's prior criminal record and the likelihood that because of the record, the defendant will pose a risk of danger to the community. And yes, the state has now filed a notice of enhancement and for impeachment, and the fact that the defendant was released on bail on this charge and has been charged in numerous other cases. And I don't dispute Mr. Spratt's argument that he is entitled to a presumption of innocence. But nonetheless, it is a factor that this court must consider, is that the fact that the defendant has a prior history and the fact that he was released on bail and committed these additional, or at least allegedly committed these others and was charged with it. And I would simply point out there's some case law that pretty well establishes that, and this is, I'm citing from the State versus Mason, which is a Court of Criminal Appeals from 2016. And it is, the court states there that the trial court correctly revoked the defendant's bail based upon the need to protect the public safety after finding that the defendant had threatened others, including members of the district attorney's office, inquired about purchasing guns from a pawn shop and described as being vulgar and angry. Well, he was not convicted of those offenses in that case, but he was charged with, or at least there was evidence of that, of those threats being made. I am of the opinion that the fact that he was originally on bond in this case and was charged with not one but 2 counts of rape while being on bond for a sexual battery makes him a threat to the safety of this community, and therefore the court declines to reinstate his bond in this case and orders that all bonds that he has previously had in all cases are revoked. And he will be held pending the trial in all of those cases. That's the order of the court.
Your Honor, may I ask, I'll ask Madam Clerk, I'll be asking for the transcripts from that, Your Honor. Thank you, Judge.
All right, we're ready to start back on the State versus Patricia Kelley. Anything before we bring the jury in? You will turn on your microphone there on the table or come to the podium, one of the two.
Judge, I have a motion before the second witness. And if we want to go.
Who is the second witness?
The second witness will be a social worker from Vanderbilt.
Okay.
And so we will be discussing a lot of what she observed. Judge, I had filed a motion pretrial to try to tamp down inflammatory comments about the parents that have nothing to do with anything. And we clearly ran foul afield of that yesterday when we ended up talking about a mom chasing dad with a butcher knife. So I would like to once again ask that before any bad character or specific instances of conduct of either parent is brought up, that we would have a jury out hearing, because as of yesterday, I was in the position where I could object and make more of an issue of it, or just sit with the bell that can't be unrung. So I'm once again asking any bad character information be kept out, or at least a jury out hearing that conforms to the rules of evidence.
All right.
I'm also asking, within those medical records, they are talking to dad, trying to figure out from him what happens, and there are several instances that he relays statements by the defendant. Judge, it would be inappropriate for the defense to bring those in as self-serving hearsay, and so I'm asking for that to be prohibited, that her statements not be entered as self-serving hearsay through the testimony of the social worker or the doctor.
Mr. Belmeyers, what she's essentially asking is that before any of that evidence comes out, that we have a jury out hearing.
Well, first, I want to say that this isn't once again asking. She filed a motion that wasn't heard, so it wasn't before the court to tell us not to make any of those statements. Her motion she filed states 404B. As the court's well aware, 404B.
I don't have a copy of that motion. Do you have a copy of the motion? Was the motion filed this morning?
No, sir, it was filed last week, I believe.
Okay, well, maybe it's in the file.
The 404B only applies to criminal defendants. state never can rely on 404B. It's impossible. They don't represent criminal defendants. That's in the notes to Rule 404B.
I found it. So you want to have that jury out hearing now?
Well, I guess what I'm saying is there's absolutely no grounds for 404B by the state ever. I mean, 404B only applies to criminal defendants. Persons in 404B has been defined over and over and over to only mean criminal defendants. It's in the notes in the notes of the rules. It also comes from State versus Stevens, which was a Tennessee Supreme Court case in 2002, relying on State versus Dubois, a 1997 Tennessee Supreme Court case. I don't understand how that could possibly be grounds for a motion, but if the court wants to have jury outs regarding all the history of the parents, we can. And I believe the father made it an issue in the case. State objected to the history of violence, and then he testified that he whips the kids with a belt. I think he was very explicit about how he whips the kids with a belt, and that he's done it so much that now showing them a belt puts them back in line, so he doesn't even have to whip them anymore. So I think that's been brought in. It's been.
So we are arguing the motion. We are arguing the motion.
I guess the point I was trying to make is this is the first time it's been before the court. The motion was never heard. It was acted like that I just disregarded some court order that.
I'm not concerned about, she herself admitted that she didn't object, and therefore there was nothing inappropriate. Without an objection, there's nothing that the court would find was inappropriate about that. So it really becomes just an issue of whether or not that is something that we'll have to take up. And I'm going to give you both an opportunity to be heard on it, but let's get forward with the case while the jury's waiting, and we have to do it before the thing. I would simply point out two things. The 404B does apply to a criminal defendant. My understanding is that the state is looking at Rule 609 in their motion, which is impeachment by evidence of conviction of a crime, which I'm not sure would apply either. That's why it's going to have to require that we have some sort of hearing outside my process is this. When this witness is called, the jury will be sent out. We'll have a hearing where you elicit whatever it is that you want to elicit. You elicit whatever you want to elicit, and then I will decide whether or not any of those are objectionable and should be admitted or not. We'll do it all. We'll have a trial run outside the presence of the jury, and then I'll make my ruling. I am obviously going to have to apply both the rules of evidence and the constitutional right of a defendant to present a defense, so that if there are alternate explanations for injuries to a child, the defendant should be allowed to bring out evidence that would substantiate their theory that some other person committed that offense rather than them. So I have to balance whether or not that evidence goes to that issue, or whether or not it should be excluded because it is not relevant, or it doesn't fit within one of the categories. So we'll deal with that at the appropriate time. Once I've heard what the proof is, then I'll have a better opportunity to make that decision. So,
Judge, I need to bring a statute to your and the defense attorney's attention. 24/7, Tennessee Code Annotated 24-7-125 was enacted in 2003, and it takes Rule 404B essentially and applies it to all witnesses, not just defendants. It does require a jury out hearing upon request, where the person putting forth the evidence shows that there's a material issue other than conduct conforming with a character trait, and it must be proven by clear and convincing conduct, and it must be excluded if the probative value is outweighed by the danger of unfair prejudice.
all right, there we have it. We'll take a look at that at the appropriate time. We are ready then for the jury, so let's bring the jury in, Officer Gunn. Good morning again, ladies and gentlemen. I hope you all have your sugar rush and you're ready to pay attention to the proceedings. So the state is still putting on their proof, and that sugar rush has to do with the fact that the jurors brought their own donuts because our clerk has fallen down on the job. So, all right, General Bryson, you may call your next witness.
State calls Ann Post. I need to retrieve Exhibit 2.
Good morning, ma'am. If you'll come around here, raise your right hand and face our clerk to be placed under oath.
Are you Ann Post?
I am.
And for our court reporter, that is Ann with an E.
Yes.
All right. Ms. Post, what do you do?
I'm the director at the Montgomery County Child Advocacy Center.
What's the Child Advocacy Center?
Well, it's a place where investigations of allegations of severe child abuse are sort of centralized. So one of our primary functions is conducting forensic interviews when there have been allegations that kids have been severely abused. And we also track all cases of severe abuse in Montgomery County. We provide victim advocacy for families that are going through this process with us. And we have a therapist on staff as well who does counseling with children who mostly with children who disclose sex abuse in our center.
Okay. Before we dive deeper into that, have you prepared a CV for the court today?
Yes,
I'm passing you what will be Exhibit 4. What is it?
it's my CV.
All right. What does CV mean?
Curriculum vitae. It's really a list of all of the training that I've done that's really relevant to the work that I currently do. So training that I've both participated in, ways I've been trained, and then also presentations that I do or classes that I teach others around the same topics. And it includes all my work experience as well. It's relevant.
Judge, for the record, the same has been provided to the defense. On a basic level, what are the qualifications to do the job of a forensic interviewer?
Well, in Tennessee, there's some that are set forth in statute, actually. And so you have to have a bachelor's degree in one of many fields. Mine is actually in human services. You need to have at least 3 years of child serving professional experience before you can be, that actually has changed to 1 plus some additional training requirements. But I had more than that. And then there's training about the actual skill of forensic interviewing. You do a 40-hour training before you ever speak with children. You are then supervised while you begin the process so that someone who's experienced can look at your work and make sure that you're applying all the principles and the science of forensic interviewing to the work that you're doing when you're talking with children. And then there's ongoing training requirements as well.
And how long have you worked as a forensic interviewer?
23 years.
Have you ever testified as a forensic interviewer before?
Yes.
Judge, at this point, I would move Exhibit 4 into evidence, and I would also ask that Ms. Post be deemed an expert by the court in forensic interviews.
Any questions? All right, Exhibit 4 will be admitted, and the witness will be qualified as an expert in the area of forensic interviews.
Now, we've called you an expert in forensic interviewing, but what is a forensic interview?
So a forensic interview is a process of trying to take a really careful statement from a child about experiences they may have had. So it's typically going to be developmentally appropriate. That's one of the tenets that you're trained in, is making sure that you're talking on the level of the child that you're speaking with. It is also designed to be open. The questions are supposed to be open-ended as much as possible, or at least that's where you start, right? Some little kids can't respond to those kinds of questions, but you start with open-ended questions that are non-suggestive and non-leading. The interviews in really everywhere now are recorded so that investigators can see them, so that juries can see them and courts can see them if they are relevant to proceedings that go forward. They're child-friendly, so I sound really nice when I talk to children. And they are also observed by investigative partners who have responsibilities for conducting the other parts of an investigation that happen.
So what is, why has the court system come to prefer forensic interviews as opposed to law enforcement interviewing kids?
Well, for one thing, the research around how children communicate and how they respond to questions we ask them, that research happens all the time, right? There's new research all the time. There are whole journals dedicated to it. And one of my responsibilities as a forensic interviewer is to stay on top of that research or to continue to be trained in that field. That is typically not one of the primary responsibilities of law enforcement. In addition, our interviews are recorded. And they're done I'm typically dressed in casual clothes when I'm talking with children. The environment is very child-friendly. There's toys in the waiting room, not so much in the interview room because we need to stay really grounded in reality in that room. But the room is soft in the sense that there's a couch and a chair, and there's usually something that a child can do in the room, like either Play-Doh or drawing or that kind of thing. I think that primarily the process of a forensic interview is both something that is supported by science and the science changes or the science gets more refined all the time. And we are obligated to keep up with that, right? And law enforcement has so many other training requirements that they have to keep up with. It's a specialty.
Let's talk about how interviewing a young child, say a 4-year-old like we have in this case, differs from interviewing even a 10-year-old.
Right. So particularly before school, children communicate very differently than they do once they start going to school and having some sort of shared experiences around communicating with adults, communicating with teachers, and that kind of thing. So little children, like a child who's 3 or 4, we really only expect them to be able to tell us who did something and what they did, and maybe where that happened, right? And then the contextual information or other things that go with that, or help us understand it in a different way, they may be missing, right? Because kids just don't communicate that way. Anybody, I think, who's talked with a 3 or 4-year-old probably knows that sometimes it's a hit or miss proposition, right? In terms of how much information you get or what they have retained or what's important to them in that moment. 10-year-olds, by the time you're 10 to 12, you're really approaching adult levels of suggestibility. So we're less worried about being leading and suggestive with kids of that age, although still concerned. And they have a more robust way of talking, right? They can tell us more about their lived experiences at that age and respond to our really grown-up questions with more of the information that we really love to have.
You talk about suggestibility. Is there a wrong way to ask kids questions?
There are definitely preferred and less preferred ways, yes. And yeah, I think there are wrong ways, right? Leading questions in particular would be not okay. So asking or misleading questions in particular, trying to trick a child is not a good way to get information from them. Asking kids questions that include both the question and the answer, like saying that happened to you, right? Would be considered a leading question, right? And really kids, I think, are vulnerable to those, and younger kids are more vulnerable to those. So we have to be cautious when we're interviewing little children.
Let's talk some about questions kids can't understand. How does a child react when they can't understand a question?
Right, so there's some new research about how kids, the title is something like how children signal incomprehension. But it's really how kids show us that they don't understand a question. So in forensic interviewing, particularly with kids 5 and above, we provide something called instructions at the beginning of the interview. So we ask them to tell us if they don't know an answer, to tell us if they don't understand something that I'm saying, and also to tell me if I make a mistake, right? And so the ways that I say those things to kids are a little more colloquial, I think. I mean, so they're a little more casual than what I just said to you all. But we do ask kids to let us know if they don't understand something. So this research looks at that sort of period of the interview where we're talking to kids about, tell us if you don't understand something. And we ask them to practice that by giving them a question that's hard to answer or that they may not developmentally be able to answer. For example, I might say to a child, what if I said, what is your ocular hue, right? And they're like, they respond. And if they know the word ocular hue is eye color, then they might answer. But if they don't, then I say, so what I mean is, another way to say that would be, what color are your eyes? And then they may answer that question, right? So, but the way kids tell us that they don't understand can be, especially younger kids, they often say, huh? Or what, right? They're asking sort of for repetition because they're not sure if they even understand the words. Or maybe they say, I don't know. They signal some kind of I don't know response. Younger kids in particular signal that way. Older kids may ask for specific clarification, like, I don't understand that word, or, or even saying, I don't understand. But little kids really are more likely to signal incomprehension those other ways by saying, huh, or I don't know, or some other way.
Asking a young child, and you remember a little bit of the facts of this case, but asking a young child questions like, how did you get hurt, or who hurt you? Could those be confusing questions?
I think it really depends. So particularly for ages 3 and 4, right, are really little kids who can talk to us about stuff and can be really good witnesses to events in their lives. They also don't necessarily generalize language the same way that grown-ups do, right? So one of the skills that kids learn really early about language is that that's a chair and that's a chair. They look different, but they're both chairs. And so they're putting things into categories. But it's not something that they do perfectly when they're little. And so if hurt is not a word that that a child understands to be related to a particular event or a particular thing, then they may or may not know.
Did you do a forensic interview with Raynell Clinton Jr.?
I did.
Okay. And I'm going to pull that up on the screen and ask if you recognize it.
Okay.
And for the record, I have retrieved Exhibit 2, and that is what we're putting up. We've got a few minutes of silence here at the beginning as it's playing. Can you describe to us what we're looking at?
That's the interview at the interview room at the Montgomery County Child Advocacy Center.
And we have a picture-in-picture. Are those just different views of the same room?
They are. There's 2 cameras, one in each of the corners. Each of the far corners.
I need to learn a lot of stuff about you, okay? Okay. Can you sit in the big chair for me? Okay.
Well, you do have pencils.
Do you have pencils? Would you like to draw while we talk?
Yeah.
Okay, let me get that set up. You got a first pencil?
So, my favorite color is,
Here.
do you have pink?
Got a pink?
Yeah.
All right, I'm going to pause for just a second. So the 2 people on camera, that's you and Raynell Clinton Jr.
Correct.
Does anybody else come in?
No,
Okay, so that's normal in a forensic interview, that's just the 2 of you.
it's just the 2 of us in the room. Yes.
Yes.
Yes. Do you see pink in there?
You see. Yes.
You do?
See.
You see.
Yes, you do. See.
Yeah, I do see. On the table, okay? There you go. All right. So Junior, I have some pictures that we need to talk about in a little while, okay?
I'm going to pause one more second. I'm at 1 minute and 38 seconds. So the date we see at the top, this interview, is that the correct date for this interview?
It is.
Okay, so that's going to put us kind of peak COVID, so you've got on a mask.
That's
and-
correct.
Okay, that's not your normal interviewing procedure.
It is not. It does not happen anymore, but that was the protocol at the time to keep everybody safe.
Okay. I'm going to resume play.
Pink. We're supposed to do a circle.
Okay. How old are you, Junior?
3.
You're 3.
Yeah. So you.
Tell me something you like to do.
I like to do drawing.
You like to do drawing?
Yeah.
We can do that together in here. What else do you like to do? Can you hold the paper?
Yeah.
Can you use that hand to hold the paper? Can I see?
This one?
Use this hand and just put it down on the paper so it doesn't move while you draw on it. So like I do like this. There you go. How does that feel?
Circle.
Circle.
Circle. My head. That's my head.
That's your head. Okay.
And
What else do you like to do besides draw?
my eyes.
Yeah. Where do you sleep, Junior?
I sleep in driving.
You sleep in Jeremiah's room?
Yeah.
Yeah, okay.
And this is the big circle.
It is a big circle. What color is that?
This is purple.
Purple. Very nice.
And this is pink.
Okay.
Yellow pink.
Do you know?
No, I'm done with pink.
You're done with pink? Pick a different one. If I can actually doesn't roll off, okay?
This first.
Yeah.
That.
Junior, who lives in your, it may need sharpening. Yeah, try this out. Try one of these. Try this one.
Oh,
How's that one? And I have another blue too.
this is bright blue.
That's bright blue.
Yeah,
Okay.
and dark blue is dark blue.
Tell me about Jeremiah's room.
Well, there's a lot of toys, and they're about to get some rats.
There's 2 rats.
And they're about to get some rats.
They're about to get some rats?
Yeah.
Okay. How come they're about to get some rats?
Well, if we keep leaving the food down,
You keep leaving the food down, you'll get rats. Who says that?
Daddy.
Daddy did. This one?
First, I would get yellow.
Okay. There's yellow,
And
you're right.
these colors.
Yeah, you can try, they're not, I need to sharpen them, they're not.
White blue first.
There you go. I like how you're using lots of different colors.
Just my eyes are little.
What?
My face.
What's your face?
Oops. Here's the face.
Here, I'm gonna draw a face. And then I'm gonna ask you a question about it.
Just my face.
How does that face feel?
And I forgot to draw my lips,
Just-
my hair, and hair.
I'll do that in a little bit, but this is just a face. How does that face feel?
Certain.
Is that face happy?
Just oh, good. And my grandma is bigger than that.
Okay. Who lives in your house? Oops.
Daddy and Drea.
Daddy and Jeremiah?
Yeah.
Does somebody else live there?
Now that is white first. Oh, yeah, white. And then white. It is white.
Yes, it is white. No, that's just a pen.
I don't want to color.
Okay.
Where are white? Here's white. And this is white.
That is white. Look at these faces. Tell me about them.
And this one is daddy, and this one
This one is Daddy. What is this one?
and Drea.
How does that feel?
And this one's me back.
That one's you.
And this one is Satan.
Who?
Satan.
Satan?
Yeah.
Who is Satan?
He's a kid that, well, he said that's time. But Taco Bell, he said Taco Bell.
Tell me again.
He said Taco Bell.
You said Taco Bell?
Yeah. He doesn't talk.
Okay. Do you go to Taco Bell?
Well, no.
No. What do you like to eat?
I like to eat sandwiches.
Sandwiches? What kind of sandwiches?
Like the one is, where Daddy feeding me.
Where Daddy feeds you?
Who feed? I mean, yeah, this one.
Okay.
These are wild wings.
Yeah.
This one was green. This one.
Yeah. Hey, Junior. Can I see your hand?
Right. This one.
Sure. What happened?
Well, great time you up. I got cut by glass.
Granny tied you up and you got cut by glass? Tell me everything about Granny tying you up.
Well, I try to get out and I get out.
You try to get out and you get out, and then what happened?
He tied me out real good.
What?
He tied me out real good.
Who tied you up real good?
Thank you.
Granny did. Okay, you tried to get out and you got out, and then Granny tied you up really good?
When I can't get out,
What did she use to tie you up?
he used a saw and a rope.
A sock and a rope?
Yeah.
Where was the sock?
Well, he put like a black one.
A black sock?
Yeah.
And what did Granny do with the black sock?
He put on my,
On your foots?
yeah,
On one foot or more than one foot?
two or one.
Okay.
So is this black?
I think so. And tell me about the rope.
So you have to draw the black saw.
You have to draw the black sock. Okay.
I'm gonna draw a house.
Okay.
I draw a house.
I draw it like that.
Oh,
Okay.
any color.
Junior, when Granny put the sock on your foot, did she put both feet in one sock? Or one foot in one sock?
Yeah,
Which one?
like the black one.
The black sock.
Yeah.
And what went into the sock?
You put two of the socks on me.
2 of the socks. Why did she put 2 of the socks on you?
Because he I know.
Okay, okay. And which parts were tied up?
I don't know.
You don't know. Can you show me where the ropes were? Where the rope was?
Yeah,
Show me where the rope was.
there was here and here.
Okay. Where on your body was the rope?
A body?
Uh-huh.
I don't know.
You don't know. Okay. So can I see your hand again? When I was looking at your hand, you said you got cut with glass and you got tied up. Granny tied you up. Is that right?
Yeah,
Okay. Where did you get cut? Show me the part that was cut. You point to it?
right here.
Right in there was cut. And where did you get tied up? Show me the part that was tied up.
I was down in the basement.
In the basement?
Yeah.
Okay. How'd you get to the basement? What made you be in the basement?
I can tell you again. Get that.
Okay. Who was there when you got tied up? Granny. Was someone else there?
Yeah.
Uncle Levi? What did Uncle Levi do?
Your bottle behind me.
He threw a bottle behind you?
Yeah.
Okay. Tell me more.
So that's a face of me and Satan, Daddy, and Jaya.
Okay. That's the face of you and Zayden, Daddy, and Jeremiah.
And you forgot Maisie. Your Maisie.
Okay. Who is Maisie?
And he's good. Oh,
Is Maisie a boy or a girl?
he's a girl.
He's a girl. Okay.
And Camara's a girl.
And who else is a girl?
Camara.
Camaraya?
Yeah.
Okay. All right. Let me see your hand again. So see these dark spots right here? What happened there? What happened to your fingers?
They're boy now.
They're what?
They're boy now.
They're grown out?
And they're boy.
Okay. All right. Did something happen to your fingers?
I don't know.
Okay. All right.
So what?
How does it feel to use this hand?
I don't know. Yeah, our color is brown.
Another color. Which one is brown?
This one,
Yeah.
and this one.
Did something happen to Jeremiah?
No,
No. How come nothing happened to Jeremiah?
because he said we would choose a color is red.
You're trying to choose a color?
Is red? Like red? Oh, red? Is this red?
What do you think?
It is red.
I think so.
So, I'm discuss like this.
You just gonna swipe it?
We can erase it.
No. Doesn't have an eraser. But you've done such beautiful colors.
Yeah,
Yeah.
first.
Junior? How does it feel to use that hand? How does that feel?
Feels good.
It feels good? Okay. Let's look at these pictures together, okay? So I have a picture
So,
of,
you forgot to draw Camaraya.
I forgot to draw Camaraya. Thank you for keeping track. Okay. Is Camaraya a grown-up or a kid?
He's not a girl, he does a girl.
She's just a girl. What
Yeah,
about me? Am I a grown-up or a kid?
you're a girl.
Okay, all right. Hey, look here.
Take this thing,
Tell me about that picture.
and that's me,
That's you?
and that's Jaya,
And that's Jeremiah?
and that's King.
And that's what?
That's the controller.
That's a controller for game, okay. Where are you in that picture?
With Daddy.
With Daddy?
Yeah.
Who took that picture? Your underwears, is that what you said?
Yeah.
Okay. All right, let's look at the next one. You tell me what you know about it. What is that?
That's my baby.
It's your boo-boo? Where's your boo-boo?
Right here.
Right there. What happened right there?
And that's blood.
That's what?
That's blood.
That's blood? Mm-hmm. What happened to you right there?
I don't know.
What made that boo-boo?
I ripped it off and I see it.
You ripped it off and you see it?
Yeah.
Okay. What is this?
That's nothing.
That's nothing, okay. But that's your boo-boo and that's blood. This is number 2.
Wait. I want to see draw mine.
Okay, I'm gonna writing some words down, okay?
No, this camera.
Okay. Number 1 will be this one of you, where you said Jeremiah's there and you were with Daddy. All right, here's another one. We'll call this one number 3, okay?
It is? Oh,
What is that?
that's a wrist.
That's a wrist?
Yeah.
Do you know whose wrist that is?
And
You don't know?
that's the red wrist.
The red wrist?
Yeah.
Okay. Who does that belong to? Whose wrist is that?
I don't know.
Okay, that's fine. All right.
No, I want to see our picture of me and Joanne.
You want to see the first picture of you and Jeremiah? Is that what you wanted to see?
No, not that one.
Not that one, a different one? I don't know that I have another one. Let's see, most of them I have are kind of close-ups of these things. What is that?
That's the burn.
That's the burn. What burned you?
It's when makeup. It's rope burn.
It's rope burn? Okay. All right. Tell me a bit about getting rope burn.
Well, I got tied up, then I got rope burn.
You got tied up and then you got rope burn. Okay.
Yeah.
All right. Junior, there's just one more picture, okay?
Oh. And that's my blood hands.
That's your what?
That's my blood hands. What is this?
What is that?
I don't know.
What is that right there?
I don't know.
Okay.
Now what is this?
I don't know. I wasn't there. I don't know. So I was asking you about number 5. What made that?
And I ripped it. I ripped this. What is this on me?
Was this only? Can I see? Can you turn over a second? Can we go this way? Can you turn it this way? Yeah, okay. Okay. What made that happen?
Oh, I can have.
You talked about being cut with glass. Where was the glass?
Well, I broke it.
What did you break? That's okay, you're not in trouble. What did you break?
I break a clock.
You break a clock. Okay, all right. Where was the clock?
It was by the TV.
Oh, okay. And then what happened after you broke the clock? Then what happened?
I got tied up.
You got tied up.
Yeah.
Okay.
So I want to get a picture of that.
That's all I have. That's all the pictures I have. All right.
Is it dark blue?
I think so. What do you think?
It is.
Yeah. Hey, Junior, how did it feel when you got tied up?
Well, it feels feelings hurt.
You were feeling hurt? Is that what you said?
Dry feelings hurt.
Jeremiah's feelings were hurt?
Yeah.
What made Jeremiah's feelings hurt?
And Granny.
Granny, okay.
And I was asleep when I was tired. And when you wake up, you go and you go to sleep.
You go to sleep and he wakes up and he goes to sleep?
Yeah.
Okay. When you were tied up, were you standing or sitting or something else?
Every now
Laying down. What were you laying on?
on the floor.
The floor. Okay. And how did it feel when you were tied up?
I'm dry. It makes dress very sad.
It made Jeremiah feel sad. How did it feel on your arm when you were tied up? How did that feel?
No.
You don't know? Did something hurt?
No.
No?
No.
All right. It looks like you have a little boo-boo over your eye. Did something happen there? Right there.
Oh,
What happened?
I don't know.
Okay.
I found the steps.
You fell on the steps?
Yeah.
Where did that happen?
It happens at Grace's house.
At Granny's house. What made you fall on the steps?
Well, Grace told me to neck when I fell on the steps.
Put your phone on the steps?
No, fall on the steps.
Fall on the steps?
Uh-huh.
Okay.
So, look around the ground.
Hey, Junior, did somebody hurt you?
No. So, can I get the page, this page you
Can you get the page that I did? Is that what you asked? You can write on there, sure. Go ahead.
did? So this is,
Here.
so this is brown.
Yes.
So what you have to do is, is that how you make grass?
Make grass?
And then at your popper? Like well, that catch one, it can jump.
Do you mean like a grasshopper?
Yeah, it can jump.
It can jump.
Yeah, it can jump.
What's it called again?
It's a grasshopper.
Grasshopper.
Yeah, it can jump high.
Yeah.
It jump in the door.
Junior, who takes care of you?
And Daddy,
Daddy. What does Daddy do to take care of you?
he takes care of me and Granny.
He takes care of you or Granny?
And Granny.
From Granny. Okay.
Yeah, so this is brown.
Mrs. Brown.
Wait. So, here's pink.
Here's pink. I'm almost out of questions, Junior. Do you have questions?
This now. I'll make the eye.
You make an eye.
Yeah, how you make it?
How do you make an eye? I
Yeah.
think you did a great job.
Oh, I need blue. So, is this blue? I
Um,
need a dark blue.
okay. You seem to know a lot about colors.
How do you make the eye?
You did it. Can you hold it down and just sort of like
Like
move
me?
it back and forth?
That's how I want
Maybe. Is that okay? Good job. What do you think?
I'm gonna make a grasshopper.
You want to make a grasshopper? I don't know how
I
to
want
make
to
this.
make a big circle.
I love the big circle.
So I was rolling in the grass and then I made a big circle.
You were rolling in the grass and you made a big circle?
Yeah, and then a cartwheel.
You did a cartwheel?
Yeah.
Okay.
So
Hey, you said Uncle Levi threw a bottle
behind me.
behind you?
Yeah.
Did Uncle Levi do something else?
No.
Something different?
So just
All right. Well, hey, Junior, I think we're all done. You want to go check out the movie again?
yeah.
All right, come on, let's go.
I want to bring this page.
Well, you bring that page. I'm going to keep mine and you keep yours, okay? That sounds great. Thank you so much. Here, I'm with this. Junior, I'm so glad I got to meet you and talk to you today.
Yeah. Make it to one color.
Now, the colors stay in here, okay?
Done.
You're going to draw?
Yeah.
These stay in here. Let's get you a different color out there. Put that in there. We'll get you some crayons out there. Come on.
Crayons? I want crayons.
You want crayons?
Yeah.
Let's go see if we can find some for you to use. Thanks for talking, Dave.
I'm going to return Exhibit 2 to the clerk and ask for Collective Exhibit 3. And if you could hand those to the witness, please. Yes. Ms. Post, I'm showing you some photos that have previously been entered as an exhibit from another witness. Are those from the same collection of photos that you were showing Junior during the interview?
They are.
Okay. All right. And I'm just going to let you, the jury's already seen those, but so that they know what we're referring to, can you just hold those up and flip through them real quick? Okay. Thank you. Those can go back to the clerk. One moment. That's all the questions that I have at this time. I'm going to get this stuff out of Mr. Belmaris's way real quick. Try not to drop anything.
Bill Myers, you may cross-examine.
Morning, Ms. Post.
Good morning.
We could pass Exhibit 3 to Ms. Post, please. And could you tell us which one of those pictures is number 1 in the interview?
This one is number 1.
Is it marked on the back as A or B, or is it just
Exhibit
circulated?
3A.
Okay, so it is marked A. Okay.
Yes.
Okay. And then picture number 2, is it marked Exhibit 3B?
Are you referring to the one that I referred to as picture number 2 in
Yes,
the
ma'am.
interview? To make certain that I'm getting it correct, may I refer to the pictures that I used in the actual interview, my
Yes,
copies
ma'am.
of them that were numbered by me?
Yes, ma'am.
Yes, 3B is number 2.
And if you could just go through each one and just tell us, I just want to make sure my notes match what it is. So.
Yes, sir. Number 3 is 3C. Number 4 is 3D. And number 5 is Exhibit 3E.
All right, thank you, ma'am.
Yes.
So this video, you've done a lot of interviews over the years, correct?
About 6,500.
Okay. And so I want to talk about the rats.
Yes.
Okay, so when Mr. Junior Clinton was trying to describe the rats, he said, "We're getting rats," correct?
That is what he said,
And
yes.
so you could have taken that as they were going to go buy some rats and keep them in a cage.
Which is the reason I attempted to clarify with him.
Right, so you could take that a whole lot of ways.
Correct.
But you had to ask what he meant by that,
Yes.
and only by gathering more evidence did it really make sense of what he meant.
Yes.
So when he was just making that statement, he wasn't able to give the context of what he meant, and that's pretty typical with someone of that age, correct?
It is. He didn't volunteer the context. He did give us a little more context when I asked a follow-up question, but again, still not a ton.
And you said that a signal, or children will often say, "I don't know," as a signal that they're confused or that they don't understand a question, correct?
That's correct.
And is that like kind of like a coping mechanism? It's safe to say, "I don't know." Is that why they do that?
I don't know that I can say specifically why a child says, "I don't know." It's a way that we know from study that kids do signal that they don't understand. It's really hard when you're little to look into your brain and decide what you do and don't understand, right? That's called metacognition. And it's just not something that our little children have. Takes us a while to learn that we are thinking about things, like to be able to think about your own thinking is metacognition. And it takes us a while to learn how to do that. And so it's just recorded as a way that kids do indicate that they don't understand.
And that's, I mean, in essence, they're not able to explain, I guess, complex thoughts, like competing thoughts in their brain and things like an adult can explain, right?
I think typically that would be true.
And so that's kind of goes to that. I mean, we're very generally, but I mean, I'm sure there's a whole lot more to it. But just kind of generally, children aren't able to explain competing thoughts in their brain or different emotional pulls in their brain or things like that.
I think that kids can give us clues and answers to lots and lots of questions. I do think that kids lack the ability to look at the thought, to look at to think to themselves, oh, I'm thinking this, right? That little children in particular, like particularly before 5, really struggle with that skill.
And I think that testimony has been that children at that age, they're able to put together maybe 2 sentences is kind of the milestone at 3 years age to 4 years of age is kind of the thought that would be where most children would be at that age, correct?
I don't know that I would venture a guess about number of sentences. They tend to be briefer sentences. They tend to be shorter responses. They tend to be able to process less language at one time. So those would all be tendencies for sure. I think what I said earlier was that most kids that age can answer sort of who, what, and where questions. And even where is an outlier for kids who are 4. So some kids can and some kids can't.
So when a child of that age is trying to describe like an event, per se, so if you just said what happened yesterday, maybe they can tell you what happened, and maybe they can't, right? It's kind of inconsistent depending on.
Right, depending on what they remember about the event, depending on how, I mean, so it's part of the reason that we often have to ask small children more questions. It's because they don't necessarily reflect on everything that they know about an event. And so sometimes asking like, who was there and where was that? Tell me what it looked like. Those kinds of questions can focus them and allow them to look at their memory and figure out what they can share.
And would a 6 or 7-year-old child be able to ask all those questions to get a full picture of a story from a younger child at 3 years of age?
I'm not sure I understand the question.
Sure. So you would have to ask questions to develop a story, right? That was your answer generally.
I don't like your phrasing, but that's okay. So I think we ask questions to help kids understand the information that we are looking for or that we want to understand if they have it.
Sure. And so I guess what I'm asking is a kid that was 6 or 7 years old, would they be able to answer or ask the type of questions of another child that was 3 or 4 to develop a story fully?
So the 6-year-old is asking questions and the 3-year-old is responding,
Yes,
3 or 4
ma'am.
is responding? I don't know how to answer that. I think that children communicate with each other in all kinds of ways. It's different, I think, than how the interview goes, which would be sort of my area of expertise.
Okay. Now, the faces, so there were some faces discussed on the video. I mean, you weren't drawing people, right? I mean, it was.
I'm not a very good artist either. No, it's called the Feeling Faces. It's a tool that was developed, I think, by a clinician named Karen Saywitz. I could be wrong though, but it really is. They're faces that have different expressions on them. There's typically 4 of them, and it really is. I was using it only as a rapport building tool to see if he would talk to me about things that make him happy and things that make him sad and things that make him surprised or mad. That's what the faces are intended to look like. It didn't work.
I guess what I'm asking is, are they just circles with like facial expressions,
They
like
are indeed.
emojis?
Yes.
It's not like pictures of people. You weren't trying
No,
to draw
super
portraits.
crude
or-
emojis.
Okay,
Yes.
all right. Now, You also said that at 3 or 4 years old, that children will categorize things.
They're learning to categorize things. That's one of the developmental skills at that age. They're learning that each individual thing doesn't have a name, that there are categories of things.
Okay. And I guess what I'm asking is, so when they're describing something, they're going to use the closest thing to describe that they understand or they know.
Typically, I would say yes, I think.
Like, I guess the example would be if a child is describing a vehicle and both their mom and dad drove trucks and they called their vehicle my truck and mama's truck or daddy's truck, then that child may describe every vehicle they see as a truck, whether it's a truck or not.
I think that that is possible. I also think it's possible that if I ask that same kid what car their mom drives, they're going to say, my mom doesn't drive a car, right? Because they are so concrete at that stage and are just learning to put things in categories. Of course, vehicle's a little hard for a 3-year-old. I mean, not that this is relevant to the, specific interview or the specifics of the things that Junior and I spoke about. But
I guess what I'm asking is, if that child hasn't never really heard the term car, and in their home, that's always talked about truck, if you ask them about a vehicle traveling down the road, they're probably going to call it a truck,
or they may not have a word for it
or may not have a
because they
word
haven't
for it
learned
at all.
categories the same way, right?
Right.
Yeah, sure.
And so the first time you may ask them, they may say they don't know what it is, if they don't have a word for it.
Sure. That is one way kids show us they don't understand something.
And over time, if you ask them over and over and over and over and over again, they're going to start searching for the closest word that they can associate with that to try to give an explanation, aren't they?
I do think that kids, when we ask them questions over and over and over again, the same question over and over again, they sometimes think that they didn't give the right answer and they try a different way.
And I think you said before school, children communicate differently.
Right, so school is kind of a rough cutoff. Once kids go to school and they're in groups of other children and they're interacting with teachers and often interacting with texts, like with books and things, they tend to talk differently and provide more language. And they're also just developmentally more able at that point. They have more language, they have more cognitive ability. That's why school starts when it does.
Okay, well, that was going to be my next question. Is it age dependent or is it school dependent?
Well, it depends. And so, of course, every child's an individual, right? But so if we're looking at general terms, we think of kids as, I think it's both, right? I think that that school does enhance kids' abilities to communicate, but also that kids who are growing up in a non-school environment, but still getting read to and talked to and so on, can still develop skills. So they would still develop linguistic skills as well.
So,
I'm not sure I answered your question.
Sure, I guess what I'm asking is, if a child starts preschool or Head Start at 3 years old, are they going to start developing quicker or sooner or earlier in life than a child that didn't start that?
I think it's hard to say, and I don't know all the research on Head Start. I do think that education and interacting with books and other adults and other children does enhance kids' developmental progress.
So when you were discussing picture number 2, well, strike that, started too late, we'll start earlier and go in sequence. So when we're talking about the socks,
Yes.
so it's very clear that you ask about socks.
He mentioned the socks
He
first.
mentioned the
right.
sock, and you asked a lot of follow-up questions to get at what he meant by the sock.
Because I did not understand what happened with the sock.
He clearly didn't communicate that a sock was on his head.
No, although no, he didn't.
No, okay. And you asked him about if it was on 1 feet or 2 feet, and eventually he said on both feet.
Yes.
Now, and he clearly stated that Levi was there and threw a bottle behind him.
Yes, he did say that. I also don't have clarity on exactly what that means.
And he clearly used the term rope burn. It's a burn, it's a rope burn. I got tied up and I got rope burn.
Yes.
And in picture number 2, so I've got, in picture number 2, he stated, I don't know, I ripped it off and I seed it.
Yes.
When you were asking him to describe what that was and how it happened.
Yes.
In your experience, a child at 3.5 or 4 years old, are they able to differentiate time in regards to weeks or months of time?
So time is one of those things that's really hard for little children. It's also really hard for grown-ups, which is why people are often late, right? We overestimate our ability to judge time. But when you're very little, it's very hard to understand and express time. Does that answer your question?
Yes, ma'am, but I guess what I'm asking is are children able at that age, weeks later to say definitively something happened on this day, something happened the next day, something happened the day after, or do those lines start to blur together?
So I think time is challenging for people of every age, right? But there are different elements of time, and one of the elements of time is putting things into sequence. So if you're asking me if a kid could sequence things, that is possible, but would be a more complex skill than I would expect from a child who's 3 or 4, right, to put things into a sequence. But if you're asking me, can they say it happened on October 23rd? I think that's going to be really tough.
And I guess what I'm asking is, are they able to tell you if they're trying to convey something, when they're asked what happened to them, they're trying to convey it, are they able to convey, this happened weeks ago, this happened last week, this happened yesterday?
It's really hard for you little kids to provide that kind of information, right? Sometimes really little kids just have like 2 time frames. It's either now or yet everything else is yesterday, right? And so yes, time information is very hard for small children.
And so in order to get a timeline, that would have taken a lot of questions to try to establish that.
I wouldn't pose those questions to a child because they wouldn't really be considered developmentally appropriate.
Okay, all right. And then I think General Bryson was asking about proper ways to speak to a child or ask questions of a child. And you were exposed to this child for a very limited piece of time, correct?
That's correct.
And so other than what he tells you or what you might have learned in a pre-interview, you really don't know who talked with him before that or who spoke with him after that about what had happened, correct?
I don't know all those details. I do try to understand from whatever investigator requests the interview. I try to understand what has come before the interview and what statements the child's already made about what happened.
Okay. And so you wouldn't be aware of what kind of questions or leading questions or suggestive questions had been asked of the child before you spoke with them?
I would not.
State have any redirect? All right, thank you, ma'am. You are released to go about your business.
Thank you, Your Honor.
Thank you.
May I stay for the part of the trial?
Pardon?
May I stay in the courtroom for part of the trial?
You may stay in the courtroom or you may leave, yes.
Thank you.
Sorry. Are we still needing to deal with that issue? There is a matter I need to address anyway. So, ladies and gentlemen, if you'll step across the hallway, we'll call you back in just a little bit, hopefully, and resume where we're headed. All right, it's been brought to my attention that a witness for the state apparently opened the door to the courtroom looking for the bathroom, and then I think a bailiff dealt with it. Was that you, Officer Moore? Oh, okay. But I just wanted to bring it to your attention in case there's any questions about it. If you want to turn your microphone on when you're standing there.
Your favorite. Yes, Judge. Our victim witness coordinator noticed that she popped her head in looking for the bathroom and then immediately stepped out. I don't believe she heard any testimony. I'm happy to bring that witness in if you would like to ask her that before she
Bell Myers, I'm bringing it to your attention because it was brought to my attention, and I don't want any issues arising from it, but from what it sounds like, there's not any issue to deal with. So.
Sorry, it was Miss Deese.
Who?
Carrie Deese. She is the social worker from Vanderbilt. So her hearing anything about the forensic interview would be of limited.
That was gonna be my next question, was it during this, I don't think that their testimony should overlap at all.
Well, number one, the purpose of the rule is to prevent witnesses from sitting in and listening to the testimony of other witnesses and thereby tailoring their testimony to avoid any contradictions or to tailor their testimony to make a contradiction where it might otherwise apply. The purpose of the rule is to preserve the testimony of that witness who is yet to testify as being isolated from the testimony of other witnesses. I don't find that the witness looking for the bathroom, sticking her head in the courtroom, constitutes any violation of the court's rule of exclusion of witnesses, and therefore I don't find that there's anything to be concerned about. Let's just make sure, where are they that they could even access it? I thought you had to have a key to get in that area, or a key fob.
So Judge, was it this door that she came in? Okay. Judge, there is, the DA's office has a space between the two courtrooms that is accessible by fob. And so that is where we keep witnesses so that there's no interaction in the hallway with anyone.
Ms. Renee, if you just make sure they know which way to go to get to the bathroom and not to come in this direction, we'll go from there. All right. Well, I think it was the right thing to do to bring it to my attention and let us deal with it on the record so that there's no issue created. I do not find there to be any violation of the rule, and therefore it's not an issue. All right. Are we going to then go ahead and deal with this other issue? Mr. Bell Myers?
Your Honor, I don't even remember when it happened, or bringing these issues to light. So two of our witnesses walked in, saw them walk in, and I don't even know if anyone was testifying. You know, again, but I felt like if that
The
person.
rule is that the counsel are under continuing duty to ensure that the rule is complied with. If you saw them here and you sent them out, that complies with the rule. And there's nothing. The only way that I would find a violation is they're sitting in here or they're peering, you know, if they've got their ear to the door, which has happened before, listening to the testimony, then that would be a different scenario. All right. Then do you want to go ahead and deal with this witness issue before we take a break, or do you want to take the break and then deal with it? How long is this witness going to be?
My portion, thank you. She turned the microphone on for you, Judge.
I'm deputizing you to ensure that General Bryson's microphone is turned on.
Judge, my paranoia, I turn it off so frequently.
It's okay.
Agent Humphreys, my portion with Agent Humphreys is maybe 20 minutes.
So is it Agent Humphreys that's going to be the witness that we're talking about?
I spoke wrongly this morning when I said the second witness would be Miss Deese. I'm going to call Miss Humphreys next and then Miss Deese. Miss Deese is the one I think where we
The social
have a
worker.
minefield, yes.
All right, then let's go ahead and just take our mid-morning break. Let's just take about, I guess, 10 minutes if we can, since I've already sent the jury out. And then we'll come back in about 10 minutes and start with Agent Humphreys. Difficult to refer to her as Agent Humphreys.
I have gone through so many iterations of titles. I'm trying to keep it straight, Judge.
All right,
Your Honor, as far as dealing with that other issue, most
your
efficient,
microphone on
it is.
there? Move it over in front of you. And
The most efficient way may be to have that short break after direct, deal with it at that point. That way I know exactly what I'm going to get into
You're
on
talking about the
cross.
social worker?
Yes, Your Honor.
Okay.
And that way I know exactly what questions I'm going to get into on cross what I don't want to do is have it early and then decide I need to ask something else I didn't anticipate.
What I'm going to do is allow the state to put on Agent Humphreys as their next witness, and then when we get to the social worker, we'll see where we are. And I still think if we're going to have a jury out hearing, do you want to have that jury out hearing after she has testified on direct and then before the cross-examination?
That's fine.
That would be that if it's something that the defense is wanting to elicit from the witness that the state's not wanting to elicit, then in my opinion, the most advantageous way would be let you put the witness on the stand, let him testify, then we'll take a break to allow the defendant to cross-examine and elicit the testimony he wants to, and then I'll consider whether or not that's proper or improper. All right, we're going to stand at recess for 10 minutes. Will you inform Officer Gunn, will you inform the jury that we're on a break for about 10 more minutes? All right, where is Mr. Bell Myers?
I'm not his keeper.
Let me see your intern in the sling.
Lily?
Come on up. What did you do to yourself? You're a cheerleader and you hurt yourself. So what did they do for you? Now, the reason I'm asking you all this is because I just was wearing one of those slings for about 8 weeks ago. It's not much fun. I had to have a total shoulder replacement because I tore everything loose in my shoulder except for one muscle that attached to your rotator cuff. I tore 3 out of the 4 muscles in my rotator cuff and my biceps tendon. And so the only thing they could do is do a total shoulder replacement. But I'm a little bit older than you are, so I was hoping you hadn't had to go that far yet. I didn't tear mine tumbling as a cheerleader does. How long are you gonna have to wear that? So did they have to go in and do actual repair to the shoulder? Okay. Was that arthroscopic or did they have to do an incision? Yeah. Well, that's good because doing the major surgery like I had, it leaves a substantial scar. So. Okay. Well, I couldn't help anytime I see someone wearing that, I'm sympathetic to what you've had to go through because I've been there and done that. So. Okay. Well, hang in there. It'll get better.
Oh. Yes, Judge. Sorry. We were discussing.
You were discussing what? You have a place to go. You have a banquet to attend tonight that we're going to get you out of here in time to attend. So what time do you need to leave? Normal time meaning 4 o'clock? What time, I'm asking you a direct question. What time do you need to leave? All right, leave this courthouse at 4:30. All right, I think we are ready for the jury. Anything before we bring the jury back?
Just Mr. Belmar and I have discussed
Effort to try to make sure I did it.
Back on.
I left out a whole section of question or at least one question about that the general didn't object to regarding that father stated that Levi had been violent with children and things like that. So,
All right, so you have a stipulation, and we're going to have that read to the jury? What is the stipulation saying?
I'm getting ready to do that now.
Okay. So do we need to hold off bringing the jury in until?
If we could wait one moment, I think it would make
one
logical.
moment? How much time is one moment? So. All right, ladies and gentlemen, I hope you all had a good lunch. Like a broken record, we've been dealing with a couple of issues, and I want to explain to you, I think earlier in the trial, I had explained to you that the parties had stipulated to certain things. A stipulation is an agreement between the parties that certain things are true. There's no inference that you should take from it other than the fact that whatever that stipulation was should be now taken as having been proven by the proof. It has been stipulated between these parties. There was a question that was not asked of the witness, Mrs. Deese, the social history expert, medical social history expert. There was a question that was not asked of her that was intended because we had a jury out hearing and then it came back. You shouldn't take anything other than the fact that it was overlooked. The parties have agreed that on a stipulation as to a question and what her answer would have been, and I'm going to read that to you. The stipulation is if Miss Deese had been asked if Mr. Raynell Clinton Sr. said, quote, Dad added that Levi had a history of physical aggression towards the patient Jeremiah, and Dad lived with a paternal grandmother in 2019. Dad claims that he has video evidence of these incidents. She would have said yes. That's the stipulation for whatever it's worth as far as that information will now be made a part of the record. We are now ready for the state to put on its next witness.
So will that be Exhibit 6 for ID? Just so I keep my numbers straight.
What is the number on that exhibit?
Will that be 6 for ID only? That's what I get for pre-numbering.
Well, we're making it an actual exhibit,
Okay.
not an exhibit for identification only.
State will call Dr. Nicholas Jones.
Doctor, if you'll come right around here and raise your right hand and let the clerk place you under oath, please. Thank you. Just have a seat there, and we're going to ask you to speak directly into the microphone.
Yes, sir. Thank you.
Are you Dr. Nicholas Jones?
Yes.
And would you spell Nicholas for our court reporter?
Nicholas.
And Dr. Jones, how are you employed?
I am employed at Vanderbilt University in the Department of Pediatrics in the Division of Pediatric Emergency Medicine.
And generally, what kind of education do you have to have in order to be emergency room doctor?
To do what I particularly do, you have to have 4 years of medical education, a residency specifically in pediatrics, and then a further 3-year fellowship in pediatric emergency medicine.
And do you have all those?
Yes, I do.
Have you compiled a CV for the court today?
I have.
Okay, I'm going to pass this up. I'm handing you what we'll refer to as Exhibit 7. Do you recognize it?
Yes, this is a CV that I've prepared.
And I would enter that, move that into evidence as Exhibit 7.
Marked as Exhibit 7.
How long have you worked at Vanderbilt?
Since July 1st, 2018, so 6.5-ish years.
And were all of those in ER pediatrics?
Yes.
Okay. Judge, I would move for him to be considered an expert in pediatric emergency medicine.
Any objection? All right, this witness will be qualified as an expert witness in the field of pediatric emergency medicine. So,
Dr. Jones, what was your involvement in this case?
I was working in the Vanderbilt Children's emergency room in Nashville, Tennessee, when this child was brought in via ambulance to be evaluated for injuries.
And were you, there's a team that usually works on these cases, is that right?
Yes. So I was what we refer to as the attending physician in the emergency room, which is sort of the supervising physician of nurses, residents, things like that. And I discussed the case with those physicians and nurses, as well as our social work team, as well as the family member that was present.
And we're going to go through some photos, but just on first blush, what was your impression of the case?
That a child had presented to their pediatrician early that morning concerning for wounds that had been found after some period of absence by the caregiver, and was brought into that office, who then redirected them to our emergency room for more specialty and higher level of care and evaluation.
Now, the child only stayed at the ER about 24 hours, is that right?
I believe, yes, in totality in the hospital, that is correct.
Can you explain why he would be kept or not kept long, or can you explain why he would be kept that duration?
So typically, when we involve ourselves in cases where there are injuries and potential allegations of maltreatment, we want to make sure that we do thorough evaluations, and that is not just an evaluation medically, which is the vast majority of what we do, but we also have social workers that liaise with Division and Children's Services and such to ensure that that child is safe to be with whomever they deem to be safe. So we will oftentimes admit to observe the wounds, make sure they're not getting infected, or if there are other interventions that need to be done for the child can be done in the hospital. And then while the medical care is going on, we also, our social work team liaises with Division of Children's Services that then starts to do their investigation and determination from there based on whatever their parameters are.
Dr. Jones, I'm going to pass you what we'll be calling Exhibit 8. If you'll take a moment to look at it, and actually you've had a moment before your testimony to look through these, is that right?
That is correct.
Are these the photos taken at the hospital documenting the child's injuries?
Yes, that is correct.
Now, there are quite a few of these. Why do you take so many photographs?
When there are injuries to a child where there is suspicion that there is maltreatment or inflicted injury, we want to make sure that we document as much as possible so that later on things cannot be called into question. They can be called into question, but just to make sure that we have a thorough documentation of what is going on with that child's skin at that time. That doesn't mean every photograph we take has a suspicious injury in it. It just means that we are trying to be complete in this record. And photo documentation, with the advent of electronic medical records and such, allows us to accurately place what we see that day into the medical record in a privacy protected way, so that we are not trying to interpret what we wrote down on a chart 4 years later to fully describe the injuries that are in front of us.
Judge, I would move this in as Exhibit 8, asked it be marked by the clerk, and then passed back to the witness. The same has been provided to the defense and comes with an affidavit from the records custodian.
All right, we'll mark it as Exhibit 8.
So in preparing for your testimony today, you were able to review both what you documented in the records and the actual photographs.
That is correct.
And were you present when the photographs were taken?
I was.
In fact, are we gonna, can you see your own hands in the photographs that we're gonna go
Yes.
through? All right, if you'll take that back from the clerk and start out with page 3. I think that's gonna be our first photo that we're gonna look at. Can you explain the significance of this photo?
So what you see is a sort of standard size-giving measuring tape there. This is the side of a child's face, and you can see There is an older mark on the forehead that appears to be well healing, and then a newer mark on the forehead closer to the eyebrow where you see some pink skin that is healing in, that is indicative of an abrasion or laceration that is healing in.
Now, is this mark on the head, could that be consistent with falling down the stairs?
Certainly, falling down the stairs, hitting the head on a side of coffee table. Every injury we see, we have to take into context with the information that we have at the time in order to determine if it's a reasonable, typical kid injury or something more suspicious.
Now, is this an injury that you would usually see in the ER?
Yes, this is something common I see multiple times a week where, like I said, a child falls down the stairs, runs into a coffee table, falls off the monkey bars, whatever it may be, and sustains a laceration to the face or abrasion to the face or forehead, because when we fall, that's what we tend to lead with is our nose and our forehead and our chin. So that's where we tend to see a lot of injuries there.
Okay. I'm next. If you will turn to page 46 in your photos there.
I have that.
Can you talk about the significance of this photo?
So here you see some more areas of where you see pink and whitish healing in skin. These are in more of a linear pattern, linear meaning line, which again are some scratches and cuts that have been healing in order to, that have not fully, completely healed in or scarred in yet.
Can you go to page 48?
Mm-hmm.
And this is the same shoulder?
Same shoulder. This is just a little bit more of a different angle to sort of see. You see sort of towards the left third of the photograph, there is a mark that is pretty well healed in. That's what we would expect, you know, a fairly well healed scar to look like. And then there are some areas there where there is whiter, lighter skin that is indicating that there is a wound there that is healing in.
Are those, you described the darker and the lighter marks, are there going to be different ages of healing?
Yes, so generally when we get a cut, wound, scrape, what have you, our body starts a process to try to fix that. And when we do that, depending on how deep the wound is, the mechanism of the wound, things like that, how close the wound edges are together, there is a pattern whereby that skin, you know, you get a scab, the scab heals, falls off. There's some newer, pinker skin under that that eventually heals in, and then you get that more of that pigmented, more, for lack of a better term, healed look that you see on the left. So this would be a cut and then several other cuts that happened at different times on this child.
Okay. Can you turn to page 7?
Oops. Yes.
Can you talk about what we see in this photo?
So here you see wrist of a child and hand that reveal a area of darker, more healed in skin with an area closer to the hand and wrist that show that more pink new skin that is somewhat healing in, as well as a blister type wound on the palm of the hand.
What's the significance of these?
So when we see these sort of marks that have a definitive edge like this and do wrap around the sides of an extremity like a wrist or a forearm, we do start to be concerned that this is something that has been wrapped around tightly and has caused constriction and damage to the skin, as well as the structures under the skin, so much so that you see damage to the point of blistering or burning, or however you want to describe that, from the pressure and from the tightness of something being wrapped around.
Now, did you base those conclusions on what you're observing here or information supplied to you by the parent or patient?
So we go by what we see first and foremost, because that's the most objective evidence that we have. We take into account what a caregiver or parent says about the injury. For example, if you have an infant that comes in with a broken skull, if a parent says, oh my gosh, I tripped up going the stairs, I fell and I dropped my baby and they have a skull fracture and I brought them right in because I'm concerned, well, they won't say I have a skull fracture, but I see swelling on their head and I'm concerned that something's wrong. That is a different situation than someone who says, you know what, I noticed this swelling on my baby's head 2 days ago, and then we find there's a skull fracture there, and no one can say how that injury happened. So the injury is there regardless. We use the context of what the family says to make sort of our suspicion for, is this an accidental process or a not accidental or inflicted process, to raise our suspicion for that.
So on these injuries, is this something that the child could have tied something to himself?
I would say maybe one. Tying something that tightly to the point where you're getting skin breakdown and blistering is not comfortable. It is painful, as one might imagine. So generally, if a kid does this, it is like a piece of hair that gets wrapped around a digit or something like that, a finger, or they accidentally put a hairband on too tight, and it would be odd for it to be in 2 different stages of healing for it to be something like that. And most kids will take it off when it starts to hurt.
So you say 2 different stages of healing. We have the darker line at the top and the lighter line at the bottom. Are you saying those are at 2 different stages of healing?
Based on this photograph and what I observed that day, yes, I would say that those 2 things did not occur at the exact same time.
Based on the stages of healing in this photo, are you able to say how long they had been healing?
So dating wounds that are already healing in is a little bit tricky. There's no chart or graph or guidance to say like, well, when you see this, it's been X many days since the wound. What we know is that based on how skin generally heals in, we can give a general window and not something where we can say this happened last Tuesday at 3 p.m. But we can say this is likely something that happened a week or 2 ago to, within a month or 2, but not something where we can pin down an exact date and say, obviously, this is when it happened, with the exception of, obviously, if you walk in and you're bleeding from a cut that you say happened an hour ago, then if you're still bleeding from it, generally, that's when it happened. But there, like I said, there is not a specific guideline that I'm aware of, and that has to do with a lot with everybody's body heals at a different process. People have medical problems that may affect their healing. If someone, not a child obviously, I hope, is a smoker, that may affect their wound healing, things like that. And so it makes it a little bit tricky to put exact specific dates and times on injuries.
On injuries such as this, are we looking at days or weeks?
Based on how this is healing in, that top one, I would say on the order of weeks to a month or more. On that bottom one, I would say on the order of a week to 2 weeks, potentially a little bit longer. Again, it's a little bit individualized in that.
Okay. The next slide is going to be page number 9.
And here you're seeing a side view of some of these same wounds. You see that where the skin got roughed up a little bit more deeply, you can see some of that whitish material there. And that's just because that wound's a little bit deeper. It's taking a little bit longer in that spot to heal in, as well as some of that scabbing and pink skin at the more closer to the hand wound. And that shows, again, that is new skin that is trying to heal in and replace that scab.
Is there anything else that you need to indicate from this photo?
I don't believe so.
Okay. The next slide will be page 11.
And that is the back of a hand. There you see a wound, again, where you are missing skin that looks blistered or was potentially a blister that is now healing in from the bottom. You still have some scab material that is sticking to that wound, as well as some newer pink skin that is healing in from the bottom.
So to me, a layperson, this doesn't connect to the ligature marks. When you're looking at everything together, what is this telling you?
So if a child came in with just this mark on their hand or this wound, I would say, well, it looks like something burned you on the back of the hand, whether that was from whatever. Likely not water or something like that, because generally you see splash marks or something like that around the water. Water doesn't tend to burn in just one spot, like you pull a pot of coffee or boiling noodles out of the microwave onto yourself, which kids do from time to time. But when you combine it with evidence that there has been something wrapped tightly around the arm, you start becoming concerned that it was tight enough to cause pressure in the hand, because the hand has a lot of very small areas in it, that pressure got up to the point where the soft tissues started to become damaged and break down and cause that wound.
Medically speaking, is this wound a burn?
Medically speaking, because it's partially healed in a little bit, the best way to describe it is a wound. And so I cannot specifically say, hey, this was a hot water burn, a chemical burn, this sort of burn, because it's already healed in, and we do not have sort of an immediate sort of history or story to go with it to say this is exactly what happened.
The next slide will be page 13.
Here you see fingertips of the hand. You see some dark markings under the fingernails, as well as a dark sort of raised area on that fifth digit there. And again, in isolation, without any of the other wounds or issues going on, this might be, hey, this looks like a kid who got their hand slammed in a car door, the fingertips. Or this might be a kid where something heavy fell on the fingertips. But again, when you're worried about was there constriction at a narrow point like the wrist or the forearm, this can be seen with breakage of the blood vessels under the skin because of that increased pressure and backflow of blood vessels, or of blood into the very small blood vessels that sit at the tip of our fingers and under them.
Now, is an injury like this something that's going to show up immediately if something is tied tightly around a wrist?
It would take some time. It's not going to show up like, for example, even if you slam your finger in a car door, you may get a bruise within 20, 30 minutes. It's not immediate. This is something you're looking at on the, order of a decent period of time. Again, everybody's a little bit different. It depends on how things are tied, but this would not be a 5-minute injury. This would be a multiple dozens of minutes, if not longer, type process for this to appear.
And the next slide will be page 17. Can you explain what we see here?
Yes, this is the opposite side. Again, you're seeing a wound on the palm that is healing in. You see a circular area that has some border to it where there are some tissue that is starting to heal in.
And how's this gonna timeline with the other injuries that we're seeing?
So this, based on the other injuries, it would appear to be around the same time as the other larger wounds on the back of the larger wound on the back of the hand that we saw.
Anything else about this photo that we need to note?
No.
If we'll go to page 19. What is documented in this photo?
So on the same hand where we had the palm blister, you see another one of these raised dark areas that, again, if this were, I pinched my finger in a toy, might be a reasonable explanation, but taken with the blister on the palm is again concerning that something was constricting that extremity to a degree that blood flow was backed up and caused some breakage of the blood vessels under the skin.
And this is consistent with your earlier testimony that something would have been tied around this child's wrist for many minutes.
Correct.
All right, the next, if you'll turn to page 21.
And again, on that same side, you can see healing skin with some deeper areas where there's pink or light skin that are healing in, that appear consistent with some of the same stages as the left side. This would be the right side.
Thank you, that's all. Is there anything else about this photo before we take it down that you need to note?
No, ma'am.
Okay. Based on your observation, was this a abuse case?
Yes, these taken together, all these injuries, especially in the wrist and hands, are consistent with and extremely concerning for an inflicted injury, which is why, as part of our evaluation, we discussed with our social worker to contact the Division of Children's Services, who began their investigation. As part of this workup, we also completed some standard blood work. That is to look for outside causes such as severe anemia, low platelets, bleeding disorders, things like that. Those were completed and completely normal. We also, in this case, because we didn't have a lot of information to go on what potentially could have happened, we just had injuries. We did a CT scan of his head that was normal, which was to be expected because he was walking, talking, doing all those things. And then we also completed what's called a skeletal survey, which is a series of x-rays that looks at almost every single bone in the body for evidence of fracture. And that was also negative, but all that tells us is there was not a brain bleed, there was not a broken bone in the recent history, and that is all done out of a sense of thoroughness. And we were able to complete that. We discussed his care with some of the burn physicians and other wound care experts who admitted him from the ER to the hospital for monitoring of his wounds and then further evaluation.
Normally, when an adult is in the hospital, we're asking them to rate their pain on a scale of happy face to sad face, 1 to 10.
Mm-hmm.
Do you do stuff like that with a kid?
Yeah, so we have lots of different scales that we use based on ages. For infants who truly cannot talk, there's the FLAC scale, FLACC, it's an acronym, where we look at vital signs, how they're positioning their body, fussiness, things like that to determine their pain. For children in the toddler stage, we have, much like we do with adults, we have a scale that they can point to with different faces that say everything from big, happy, smiling face to very sad, crying face, in things like that.
Do you remember if this child was able to rate his pain on the scale?
I believe it's in the nursing notes that I do not have in front of me, but I do not recall exactly what his pain scale was at that time.
From your experience, how painful are the injuries that we're going to be seeing?
So
Judge, I'm asking the expert from his observation of the injuries and his training and experience, what he would expect the pain to be with the injuries he saw.
Well, the question was was rephrased in asking him based upon his experience. He's been qualified as an expert in pediatric emergency medicine, so I will overrule the objection, allow him to testify based on his experience.
At the time that the injuries happened, they would have been very painful. As they're healing in, you're dealing more with aches, pains, even to the point where they may not be painful unless you do a certain thing. If there's nerve damage or something like that, that would be triggered. And so at the time we were seeing him, it would not be unusual for him to not complain of much pain at that time as it's healing in.
If a child after injuries like this refuses to use one hand, is that significant?
Yes, that can mean a couple of different things. One thing it can mean is that there is some sort of pain with movement that's not there at rest. And so if moving or using the hand, just like if you sprain your ankle, you prop it up, it's not really that painful, but you try to walk on it, it hurts. There's that. It could also mean that there is some sort of nerve injury to the point where there may be the child feels some weakness or clumsiness with that hand and does not prefer to use it and instead uses another hand.
Let's add another factor to that assessment. If that hand that the child isn't using remains cold to the touch or colder than the other hand, what does that tell you?
That can mean a couple of different things. The main thing, the big, bad, scary thing we want to make sure is there signs of blood vessel damage in that hand? Is the circulation not good to that hand? And as I recall, the child's hand was pink, dry, and had a good palpable pulse. So that big, bad, scary thing was less likely. And then when you get into sort of cold versus warm on one side versus the other thing you do have to think about is damage to nerves that control things like how dilated your blood vessels are in the skin, things like that that lead to the perception of how warm your skin is.
Can that heal over time?
It can. It depends on the severity, the length of the length of the damage, how much of a nerve is damaged. It's all very individualized, and that's why we have things like occupational therapists and neurologists and all those kinds of people who help evaluate those and can prescribe a course of treatment to see what does return. In children, specifically younger children, they are much more likely to regain function than, say, I would be. And that's just because their bodies are sort of primed to do more regeneration. And again, children generally don't tend to smoke or have diabetes. That may be some of the things that influence that healing.
One moment, Judge. All my questions at this time.
All right, Mr. Belmeyers, you may cross-examine.
Good afternoon, Dr. Jones.
Good afternoon.
Under my approach to witness, or?
You may.
Dr. Jones, I'm going to pass a document. If you'll just look through that, I'm going to ask you some general questions, but not anything specifically at this point. Does that appear to be the medical records that Vanderbilt would have kept regarding this child?
It does appear to be a complete, or what I would assume to be complete medical record from this child.
On the last page, and there's a big black box. Is that significant for any reason as far as a code that's into the records or anything like that?
I am not familiar with how they routinely print out medical records because I access them through the computer, but it appears to just be the end of the packet to me.
And I didn't know. I didn't know if you would know that or not. Y'all, you look at medical records on your computer. You don't usually get them like that, correct?
Correct.
So when someone is brought into the emergency room, or I guess doctors refer to it as the ED or emergency department, right?
Yes, sir.
You're not going to be the first person that talks to the patient or the patient's family, correct?
Not necessarily. Depending on how the patient arrives and what's going on, I may be. But there are triage nurses, other people that person may interact with before they see me.
Okay. And in this case, do you know what you knew about the case and the history and referrals before you walked into the room to see the patient?
So the way our system works is it's a little bit of managed chaos, as most emergency rooms are. We receive a heads up when there is an EMS call most of the time. Sometimes we don't, where they call in with I have a this age child with this complaint who is coming in. Then they get placed in a room, and from there, there's a triage process that begins. If a child is severely injured, critically ill, there may be multiple physicians, nurses, whatever in that room at that time. For this child, I believe there had been a call in, not to me directly, as far as I recall, from the pediatrician's office saying this child was coming by ambulance. The ambulance radioed in, and he was brought to a room directly from the ambulance.
And if records had reflected that you'd had a conversation with the provider advising them to have him brought in via ambulance, do you think that's likely, that that's what happened?
So the way our call center works is they speak to either a resident physician in training or one of our attending physicians. In mode of transport, while we can make suggestions, it is up to the sending physician or facility to determine mode of transport.
Would you have advised them that in a case like this, to be transported in an ambulance rather than a POV?
So I think I would discuss with the physician on the other side in a hypothetical situation where I take a phone call like this, whether they felt that the family was able to bring the child by car and whether or not the child was stable to be brought by car. And so I feel, at this point, the child had stable vital signs, could have potentially come by car, but for whatever reason, that child was then brought by ambulance.
Okay. I mean, it wouldn't be that if you suggest, considered child abuse or that was a concern, that you would want to control how he got to the hospital rather than just letting him go off with his parents?
I think if that, again, because this is not a child that I have physically seen or interacted with the family, that would be up to that sending physician. And if they had even 1% of doubt, I would suggest to them to potentially send by ambulance depending on their assessment of the situation.
And so I want to dove right into the pictures. So I want to go back to those pictures. So page 3 of the photos was a head injury.
Yes, sir.
And you stated that in that picture there was a newer injury and an older injury on the head.
Yes, sir.
And I think you've already testified that it's difficult to determine timeline. So can you tell us the pink injury or the newer injury was how old that was?
It would be probably, based on my opinion, again, there are a lot of asterisks and caveats that go into that, on the order of a few weeks.
Okay, even the pink one would be a few weeks old.
A week to 2 weeks, if I had to pin down much more specifically.
And again, you've said that is an injury that's consistent with falling, going up or down stairs.
Correct, it can be.
And if someone had fallen down a number of stairs, 10 or more stairs from one story to another, you would expect to see more injuries than just that.
It depends on the material you're falling on, how fast you're going. Interestingly enough, falling down 10 stairs is 10 1-foot falls as opposed to 1 10-foot fall. So we expect to see a lot of injuries with, say you're on a roof of a house and you fall off 10 feet. That's different than falling 10 feet down a staircase. We tend to see a lot more bumps and bruises with fall down a staircase as opposed to fall off a roof. You're breaking bones, you've got spinal injuries, stuff like that, head injuries, stuff like that. Not to say that can't happen, especially in a small child that falls downstairs, but the physics are slightly different.
Did you see those bumps and bruises and all of that, and that would be indicative of falling down a flight of stairs versus up a stairs or 1 or 2 stairs?
So we saw the injuries on the head, we saw the healing scratches on the arm. I do not recall a lot of what we call hematomas or blood collections under the skin or fresh or even healing, a ton of bruising on the skin that I would be extremely suspicious of falling down the stairs.
And it was conveyed to you by the father that the child had cut his head on the stair and that he had broken a clock, correct?
Yes,
And it was also conveyed to you that the child had never disclosed what had happened.
that is correct.
Could you tell us, what does non-pitting edema mean?
So pitting edema, basically, it sounds fancy, but what you do is you put your finger on it, and if you put enough force, does it leave an indentation when you put it away? Non-pitting edema means there's not enough fluid under the skin to leave an indentation when you put it away. Same as if you're on your feet all day, you wear a pair of tighter socks, you get that band around your leg when you take your sock off. I don't know, maybe that's just me, maybe I should see my doctor, but that is what we would consider pitting edema. Edema just means swelling.
Okay. And so here it says, no joint swelling, non-pitting edema to the left dorsal hand with tenderness and palpitation. So dorsal means
Back.
this side, right? And so you'd be talking about the wound there. And non-pitting edema means when you press on it, it doesn't leave an indentation.
Correct.
And circumferential abrasions to bilateral wrist with burns of unknown etiology. Is that how you say that word?
Yeah.
Can you
Again,
tell us give us a definition of what that means?
etiology just means how something happened. Meaning there are these wounds here, they chose to call them burns in that medical record. But unknown etiology just means we do not have, information from either someone who witnessed what happened or a caregiver to say exactly where those wounds came from.
But when you say circumferential, you mean the marks around the arm.
Yes, sir.
And it doesn't mean around part of the arm, it's all the way around the arm, correct?
Correct.
Hypothenar,
Yes, hypothenar eminence is this area right here under your thumb.
Okay.
So your thenar eminence is that, where they tell you to touch to tell you if a steak is medium rare. That's your thenar eminence. And then hypothenar just means under this area. So about this area right here.
okay. And then again, dorsal aspect means the back, so dorsal aspect of left hand would be on the back of your left hand. And I guess, so though that was a summary of the skin findings that were found, correct?
Correct.
So it's impossible to know whether those injuries were caused from the same source, correct?
It is impossible to know if they were done at the same time, or they seem to be done in similar time frames, and they are what we would call suspicious injuries.
Sure. I guess what I'm getting at is the circumferential marks could be different than the wounds on the hands, could be different causes.
Potentially, yes.
And particularly the photo, page 7 of the medical records. I don't know if you have those with you, well, not but the photos.
The binder.
exhibit. Yes, sir.
Yes, sir.
So there are 3 distinct things in that photo, right? There's a ring further up the arm that's dark. There's a ring closer to the wrist, about where someone would wear a watch, that's dark with another spot that's more pink. I think you said it's a deeper or a different, more damage, so it stayed pink longer, right? Is that
Yes, sir.
a fair assessment? And then there's the wounds on the hands, correct?
Yes, sir.
Okay. So would it be possible that both circumferential marks were at the same time, but the spot on the wrist bled more, so if it was treated, that damage could have been caused later from treatment.
I'm sorry, can I ask for a clarification?
Sure.
When you say treatment, what do you mean by treatment?
Well, I guess the broadest sense of the term. So I'll back up and try to break that down. Is it possible that if someone, particularly a layperson or someone with little medical experience, attempted to treat this injury on the wrist, is it possible that treatment, either if they scrubbed it or they put something on it, be it hydrogen peroxide or neosporin or any other substance along that line, or wrapped it up with a bandage and later removed that bandage? Is it possible that those injuries that happened at the same time, but the treatment by the layperson caused further injury?
Generally, when you're talking about treatment like wraps or lotions, potions, whatever it may be that people make up to put on these wounds, what you're doing is you're doing what's called debridement, which is just a fancy word for saying taking the surface, the very tip-top surface scab away. The depth, the way that this is healing and the depth of that, even if you were to manipulate or scrape away the scab, yes, it may cause some more bleeding and a different appearance of the healing, but it would not significantly alter the overall appearance at this stage of healing.
Okay. And what about if someone continued to place something in that wound while it was healing? Would that cause that kind of damage?
So if someone were to continually scrub or wipe away an area, or not necessarily something like Aquaphor or Vaseline or anything like that that's more just topical, but to mechanically scrub it out, it may cause the healing to be slightly delayed or to come in at a different rate than another, yes.
And the injuries on the hand there, the blister, I think you characterized it during direct. You can't tell us really what caused that, correct?
Again, with the sort of marks that we already have established, my concern is this some form of burn, or is this a result of the backflow pressure from something being so tight around the wrist? Those would be my two main concerns. But looking at it in the state it is in currently, it is, you can't, we don't have a machine where we upload the pictures and it tells us exactly what and when happened. That would be impossible for me to say.
Sure. And when you're developing those theories or hypotheses, you're taking what you see and like what you've collected from the person providing information.
Correct.
Now, I want to make sure I understand, on direct, you did say that you felt like the progression was this wound was older, this one was newer, and this one was newer still, correct?
I would clarify with that the closer one down on the wrist and the palm could potentially be fairly close together, if not simultaneously in time. But yes, the one above is a little bit older, potentially, yes.
And there are multiple types of burns, correct?
Sure, yes.
And are you able to look particularly at the hands and tell us what caused those burns?
So there's not a way, again, there are certain clues like with splash or scald burns, those tend to have some ring of droplets or things like that you would expect around it. But in terms of, was it a hot radiator, was it a hot stove, unless it leaves a particular pattern that you can then match up to an object in the house, then it is fairly, especially at this healing stage, a little bit impossible to say exactly what the origin of that was.
Are you able to tell us if it was caused by heat, if it's a thermal burn, or caused by chemical? I think you said chemical might be another way. I mean, are you able to tell us that by that photo or your observations there on the day?
By my observation, I would not be able to tell you if it was heat, chemical, or et cetera. Most of the burns in kids this age in this country are heat-related, just because that's what they're exposed to. And, looking at the photograph, again, we take all these things in totality. So we're looking at the pattern of all the injuries, what the rest of the child looks like, to make these determinations. And again, when we have a lack of direct information, then it's sometimes we can't say exactly 100%, this is exactly what happened.
Yeah, and then that brings me back to, you said that, you have to make that kind of decision on the fly. I guess that's my characterization, not yours, in the ER, of whether you suspect abuse or neglect oftentimes.
Yes, and I would characterize it as it's a little more than on the fly. It's true we do not spend hours and hours with each patient delving into their particular life situation and exactly what's going on. My job is not an investigator for the police or anything like that. My job is to look at the injuries on the child, assess them, and then using medical training, medical experience, et cetera, discuss my suspicion that these are inflicted injuries or not. And that takes in a totality of what my physical exam is showing me, what I'm hearing from other caregivers, and then my job is to say, I am concerned about an inflicted injury on this child, and then that information gets processed through our social work team, through Division of Children's Services, law enforcement, whatever it may be, at that time usually Division of Children's Services, who then complete a more formal investigation to really sort of drill down. And, the child themselves oftentimes is part of that investigation.
That was a poor question, so I'll try to straighten it back up. But your job's not to figure out what happened. Your job is to treat the child, correct?
Correct. We treat the child, and part of that treatment is making sure that that child is safe with a particular caregiver or in a particular environment. And if I'm concerned about the safety of that child, that's when those red flags get raised. And then that's when all that investigation starts. And then it is not me, it is the Division of Children's Services or law enforcement that says, this child is safe with XYZ person, can go home with this person, or we need to do temporary placement, or whatever their determination may be from that standpoint.
And so you have an obligation under the law, if you suspect child abuse, you have to report it, correct?
Correct, mandated reporter.
Now, the injuries on page 13 on the hand, well, I guess on both hands, the dark spots or dots,
Yes, sir.
so those could be at the same time, or they could have even been minutes, I think, many minutes before your examination, they could have been caused.
I would recharacterize that to say it would take many minutes of compression around the wrist to cause those. But in other circumstances, this you may see if you pinch your finger in something that can happen. Again, if a child showed up with just those isolated fingers with no other marks on their body and they said, my hand got slammed in a door, I'd say that's appropriate. But in taking all the pattern of injuries that we have before us, my concern is this something where a child's fingers have either been crushed, or did the back pressure from the constriction cause those marks to appear? And again, there's no way to use what we sometimes call in medicine the retrospectoscope, so where we look at things retrospectively and say 100% this is what happened. Occasionally we have enough based on what we see and things like that where we can, but in this case we do not.
And I want to go back. When you were talking about you making that initial assessment, I characterized on the fly, but the other part of that is when you're making that assessment, you're taking what information you're giving when they come in and making a determination whether you feel like it could be inflicted trauma or it was an accident. That's kind of the first threshold question you're asking yourself, correct?
The first question we ask ourselves is this child stable and doing okay from a medical standpoint? That's the first question. In this child, yes. And then it becomes, when we see these patterns of injury, how concerned are we? And then we went, in doing our full physical exam, speaking with his caregiver, we made that determination that we were concerned that these were inflicted injuries.
And oftentimes, I think you mentioned, you'll see a child that's brought into the emergency room minutes after an injury.
Correct.
And even during some of those times, you might have a parent that's hysterical or concerned about the police or DCS. That happens quite often, correct?
I don't know, quite often is a little bit vague, but yes, it happens.
And sometimes you hear what they said happened, you look at the evidence, and it's easy to say, this was an accident, this parent's overreacting, that I'm not concerned.
What I tell families who are concerned about an injury pattern, I guess my question, to clarify, are you talking about a parent who's concerned that DCS will be called on themselves, or a parent who's concerned that they need to call DCS on another caregiver?
That they're concerned DCS is going to be called on them.
Right. Oftentimes I can reassure them if, like I said, the injury pattern and what's going on all is sort of very much what we would expect in a typical childhood injury. And my job is not to look at every injury and call DCS on every broken bone. That's not my job. My job is to use my medical training as well as experience to raise red flags so that those can be communicated and investigations can be done. I honestly, child abuse is one of those things where we really want to exclude everything else before that, because the last thing I want is to send an agency of the state onto a family who is just trying to do the best for their child. And so for me, the bar for suspicion for involving them is fairly high. Like I said, not every bump and bonk gets a phone call to DCS and children.
Now, and you stated that you ordered a series of tests, CT, X-ray, blood tests, all those things, and they were all negative.
Normal, yes.
And so if the initial assessment by the primary care provider, they said they had a concern about a broken bone, it's just that they looked at it, but you tested it and it didn't test out.
Correct.
And that happens often in medicine, correct?
Correct. People can fall, just same thing like a sprained ankle. You may fall and think, oh my gosh, I broke my ankle. And that's why we do x-rays, and we can say, no, you didn't break your ankle, you sprained it. And again, that doesn't necessarily mean that, whoever sent you in for the x-ray was wrong about you breaking your ankle. It just means that we didn't find any evidence that, and this is actually what's going on now that we've done the definitive testing.
And if the PCP found that the stomach or belly was distended, is that why you done the blood work or check for internal?
It's part of the reason. So part of the blood work looks at what we call liver numbers, pancreas numbers, things like that. Also, as part of the x-rays, we do get x-rays of the belly. And none of that showed any evidence of damage to internal organs, which is some of the things why we do some of that screening.
Okay. So then again, it's just you followed up, and after gathering all the data, you reached a conclusion that there was no internal bleeding or no concern with that.
Correct.
Now, so the admission of the child, an adult with less than 1% total body burns probably wouldn't be admitted into the hospital, correct?
Correct, unless there were other extenuating circumstances or injuries that required them.
And I mean, so was the fact that he was a small child, was that a factor in determining to admit him into the hospital?
Yes, and I am not the one who ultimately makes the decision for admission. That would be up to the physicians who actually accept him into the hospital and admit him. But yes, age and situation and other things, other medical conditions, things like that, those all play into those decisions.
Was the fact that non-accidental trauma was a concern, was that a fact that was used to determine whether he'd be admitted or not?
It can sometimes inform our decisions. It's not like, oh, we're concerned about non-accidental trauma, you have to be admitted to the hospital. That's not how our system works. But it does inform somewhat. And as you know, when this occurred, this was sort of the height of the first wave of COVID, when a lot of doctors' offices and outpatient clinics were shut down. And that also played a part into watching him as well.
Right, so at that time, I mean, just walking into a doctor was more difficult than normal.
Correct.
Lack of transportation, would that have been something that would have been considered?
It can be, depending on what needs to happen, like close follow-up, things like that. But these are all pieces of a total puzzle, not one outstanding determining factor.
Sure, or even the time of day. I mean, if it got way late in the evening, there was some follow-up that needed to be done, y'all may just keep someone overnight
Yeah.
because the staff would be available the next morning to do those.
That sort of thing, or sometimes we will hold people in the emergency room, let them sit in a room and, for lack of a better term, hang out until whatever needs to happen happens. And so that is part of it as well.
And so on the injuries to Mr. Junior Clinton, which one of those on his right hand would have been consistent with him bleeding profusely on August the 4th, so 3 days prior to you seeing him?
I'm sorry, I'm flipping back through this record to try to get to those. Apologize. So profusely is an interesting word because a lot of people use that word. So I would say the most suspect culprit lesions would be the lesion, the mark, the wound on the side of his wrist or from the ulcer wound itself. And profusely, I used to get nosebleeds when I was a kid, and even though it's a small amount of blood, it sure does look like sometimes a murder scene when you wake up and your pillow's covered in blood. And so the word profuse is a little bit interesting. Certainly some bleeding or oozing from there may look profuse to someone who is a layperson, but those would be the most suspect lesions, I would suspect.
Dr. Jones, you were asked about burns, okay? Does this child have burns on his hands?
So I would say he has wounds. Again, once it gets to a certain stage in healing, and you've taken blisters off and things like that, it is hard 100% to say, yes, this was a burn, but it is definitely a wound and definitely deep enough that it is taking some time to heal in, and definitely would have been a painful and a painful process to go through.
I also see in the medical records the term strung together, friction ligature marks. Okay, is that one of the diagnoses for this child?
So friction ligature marks. So ligature just means something that is wrapped around something. It doesn't imply rope. It doesn't imply any particular material. It just means something that is wrapped around to cause essentially strangulation of a body part. And friction, what they're getting at with friction is that in the base of the wounds and around the wounds, there is some signs of irritation and wound tissue damage that would be consistent with something having been wrapped around that caused the skin to break down, or that rope burn or things like that. All that means, it doesn't mean burn in the sense that you were in a house fire or you were submerged in boiling water or whatever that may be. It just means that the force of the friction or the tightness with which something was wrapped around caused damage to the skin and the tissue. We can get hung up on the word burn itself, But really, all we're saying when we're using these terms wound and burn interchangeably is that there was damage to this child's skin and soft tissues to the extent that it caused a deep enough wound to have these signs of healing in and to cause these marks.
And when we use the word burn, and I know you're using wound, were the wounds that he had something that you could categorize to a degree of burns? And that's a medical question, not a lawyer question, so it may be a no.
So degree of burns, we get taught in first aid class, first degree, second degree, third degree. What our burn surgeons and what most burn surgeons use to this nowadays is what we call partial thickness, full thickness, and superficial. So superficial burn is kind of like a sunburn. You touch a hot stove for a second and pull your finger back, and you've got a red mark on your skin that's painful. Partial thickness means that you've done enough damage to the tissue to cause some blistering and to cause the top layer of skin to come off. And a full thickness burn is truly what it sounds like, is what we used to call third degree, means you have burned all the way through the layers of the skin to cause an area that is going to not heal in well or not heal in properly. Those are the ones that usually get some partial thickness, but most often full thickness burns are the ones that get grafted. And again, I am putting on my not really a burn surgeon hat, but take care of a lot of burns hat. They could give you a much more nuanced take, but if we were to call this a burn, I would call it a partial thickness burn, which, if you wanted to use it in first aid terms, would be a second degree burn.
Can you pull up slide number 5? That's going to be page 7. So Mr. Belmaris spoke to you some about this photo. And I want to go through and highlight some things. So the marks on the wrist that we see, and we talked about how the cut on the head would be consistent with falling down the stairs. Would these marks around his wrist be consistent with falling down the stairs?
Not at all.
Are they consistent with being tied up with a rope?
Yes.
And the mark at the tip of his finger that we see here, and then if we can move back over to slide 8, that's going to be page 13. I wanted to clarify, because you and Mr. Belmaris had some exchange on this as well. When you said it would take dozens of minutes for these to develop, you did not mean time since the injury for them to show up.
Let me clarify this. So if this were a one-time blow across the fingernails, they would show up pretty quickly. But if this is from a compression, which is what we're worried about, because again, we have those marks around the wrist, it's not like you tie something around a wrist and then these marks show up 5 minutes later. This would mean there was a protracted period of time, many minutes, before these wounds would start to show up from the back pressure. And again, some of that has to do with how the hand is positioned, if it's pointing up, pointing down, all that, none of which we have, any sort of objective evidence of. What we do have evidence of is a constellation of injuries that are inflicted or appear to be inflicted and are suspicious that something has been tied around this child's wrists long enough to cause that kind of damage.
And did you need anyone to say the words rope burn in front of you before you reached that conclusion?
No, ma'am.
Are these child's injuries all consistent with being tied up with a rope for a long period of time?
They are, with the wrists and hands, those are consistent with being tied up for a prolonged period of time. Yes.
And that time would have been not in the last 72 hours before the child was brought to the hospital?
Based on how the skin is healing in from under, no.
No further questions, Judge.
Bill Myers?
But circumferential burns aren't consistent with the hands being tied together like this, are they?
That would be a little bit hard for me to say, because you could see how, depending on how you position the hands, it could potentially be that way. But as far as the actual position that they were tied in, it's, again, I'm looking at healed-in wounds. I can't 100% say one way or the
The hands
other.
were tied together with a rope or object around the hands, both hands being tied together, then you wouldn't have circumferential marks, correct?
Not potentially, no. But that doesn't exclude one hand being tied or two hands being tied separately to different objects. It just depends.
Now, can you tell us, so if someone is exposed to poison oak or poison ivy, that creates a burn, correct?
It creates a rash. I wouldn't characterize it as a burn. So what happens is the oil gets on your skin. There's an allergic reaction that happens in the skin that causes some blistering and bubbling of the skin, usually with a lot of sort of red, angry base that responds to steroids, things like that. And then it scabs over and heals in. I mean, I've done it to myself a couple of times, clearing out trees and such, and you get that kind of itchy rash. But it has a different appearance than what I would expect. They generally are smaller individual blisters, not large wounds that occur from that.
Have you ever, when pulling brush, as you said, have you ever wrapped the vine around your hand to pull the brush?
Sure.
And once you get that oil on you and you start getting those blisters, if you bust those blisters, it begins to spread, doesn't it?
What was that?
This is beyond the scope of redirect.
Your Honor, General Bryson gave him a hypothetical about causation of the circumferential marks around the wrist, so I'm just posing another hypothetical situation.
Overruled.
So if we're talking about poison ivy vines or poison oak vines that you wrap around your hand and pull, I wouldn't say, so the blisters themselves don't contain a toxin. The oil, you can spread the oil around your hands, but it's not the popping of the blisters themselves that spreads the oil. Oftentimes it's doing stuff like, you wipe your hands like that, it spreads, or you rub your eyes or whatever it is you happen to do, you spread the oil. And I would expect that if a child wrapped around a vine around their hand and pulled on it, they might have a small mark or a linear mark there, but I would not anticipate the large blisters or the depth of the wound that we see here.
Well, if they were cleaning brush and originally got those blisters and someone attempted to treat it and placed those blisters into Epsom salt, could that cause further irritation of those blisters and spreading?
It might cause irritation. I don't know if it would cause spreading. It would not cause, Epsom salts in and of itself would not cause the depth of the wound to change or anything like that.
And if that child was also treated by having gauze wrapped around their arms each day and night, and the child continually itched those galls, pulled on those galls for 2.5 weeks, would that cause those burns if they continually pulled on those galls on each hand?
It would cause irritation and poor healing, scratching. I would expect more infection because these wounds do not look infected at this time. Generally, if you're scratching and messing with it, something's going to get infected. But again, I wouldn't expect just gauze in and of itself to cause the swelling, the marks at the end of the fingers, things like that, unless it was so tight as to cause pain or discomfort.
And
Redirect. Thank you, doctor. You may step down and we'll release you and you may go about your business. Thank you.
Would you like me to hand these to anyone?
Yes, if you would hand that back to do you want that made as, was made as exhibit 8, it goes back to the, all right. General Bryson, you have another witness.
No, Judge, that's the state's case.
State has rested their proof. Ladies and gentlemen, let's go ahead and take a recess for a few minutes and stretch your legs, and I've got to attend to a few technical things, and then we'll come back to you, okay? Let's take about a 15-minute recess. We'll stand here I'm going to stay here while we give you an opportunity to go on break. State is rested, Mr. Bellmeyers. You have witnesses you wish to present. How many do you have? 2? All right. Then we'll go ahead and take them up when we return. And then, barring anything else happening, we will probably adjourn for the day. If we can get both of your witnesses in an hour, do you think? You think you can get both your witnesses in an hour, or will it? 4:30 is. Well, I will, well, we'll play it by ear, but, obviously I've told General Bryson she has a place she needs to leave at 4:30, so we'll do that. But main thing is that we will not be going to the jury with final arguments and the final charge until tomorrow. You want to go ahead and make your motion now?
I would too.
All right, that's fine. Let's do that. We'll just do it. We'll let you make your motion before we bring the jury back in. All right, we'll be in recess for about 15 minutes.
Let's count 1. The causation of the injuries. It's not sufficient proof in the record, Your Honor, to show that these particular injuries were caused by Ms. Kelley. Other folks had
Hold on a second.
access.
We need our district attorney back. Sorry, I thought I saw you, but then I look at the chair and all I see is the back of an empty chair. So, all right, I apologize. Let's go.
Other folks had access to the child in the case, Your Honor, and
I'm
in
sorry,
order,
repeat that one now. What?
the proof has not established that Ms. Kelley would be the person that caused the injuries. There were other folks that had access to the children, and in order for the jury to find beyond a reasonable doubt that Ms. Kelley was the perpetrator, they must be able to exclude other reasonable theories or other reasonable causes of the injuries or other perpetrators. Here you had the testimony of Mr. Raynell Clinton Jr. He did testify, and he couldn't remember those injuries or remember much of what happened. He did say that he was tied up with a rope and couldn't remember any details whatsoever. When asked if he had any recollection, he said he did not, but he had watched the video the day before. So he stated that his testimony was based on watching the video. He then, during his testimony, said that he believed he lied during the video. And so that video wasn't under oath. He's saying that his entire remembrance or recollection was based solely on watching a video, not of the events. As to count 2, Your Honor, Ms. Kelley is charged with aggravated kidnapping. Kidnapping requires that the person be removed or confined so as to interfere substantially with the other's liberty. The first issue is that, and it has to be unlawful. In order for it to be unlawful, it has to be accomplished by force, threat, or fraud, or in the case of a person who is under the age of 13, accomplished without the consent of the parent, guardian, or other person responsible for the general supervision of the minor's welfare. When this child was placed in Ms. Kelley's care for 10 weeks, she became responsible for the general supervision of the minor's welfare. It's been clearly established by the evidence. She was dropped off, picked up, the child was dropped off in her care, picked up from her care, and even was basically told, don't be calling me unless he's going to the hospital. She was responsible for the child's general supervision and welfare. So she would have the ability to consent where the child would go, where the child would be placed, what the child would be done. It would be absurd to say that a parent or someone with custody and care of a child couldn't use force, threat, or fraud to move that child or to confine that child. If that's the law in the state of Tennessee, then I commit false imprisonment or kidnapping every night when I take my child and put them in his playpen or his crib to go to sleep. Every person in the state would commit kidnapping when they restrained a child in a car seat. So it has to be that if the child's under 13, that it has to be accomplished without the authority of being the parent or the caregiver. To read it otherwise would lead to an absurd result. And then lastly is regarding to in order to find the defendant guilty of the offense, you must find beyond a reasonable doubt that the removal or confinement was to a greater degree than necessary to commit the offenses that are charged. So it would have to be a greater degree than the assault or the child abuse. If the state is saying, and I think that's what they've been saying all along, that the assault or child abuse was accomplished by tying the child up or restraining the child, then there's absolutely no reason that the kidnapping was necessary or more necessary or would not be the same thing as the child abuse. You would have to have an additional element that's not there, Your Honor. And so for those reasons, we would particularly ask that count 2 of the indictment be dismissed. And count 1 as well. Thank you, Your Honor.
General Bryson?
Thank you, Judge. Of course, in a motion for directed verdict, the court must view the evidence in a light most favorable to the non-moving party. You have heard testimony from the victim that testified clearly to the identity of the defendant as the person who tied him up. You have heard the medical proof that consistent with the time frame that he would have been in her care, that he has injuries consistent with being tied up. Those injuries would have been significantly painful. You heard testimony and medical proof that there was a period of time that he did not use his dominant hand, that it had symptoms consistent with nerve damage. That would be a protracted or substantial loss or impairment of bodily function, which would fall under serious bodily injury to meet the terms of aggravated child abuse. The testimony would line up that the defendant would have acted knowingly. The act of tying a rope around a child's wrist would be a knowing, if not intentional act. And it resulted in injury, the burns that are seen there on the child. And the child, of course, was less than 8 years of age. Switching to the kidnapping statute, you have heard proof that the child was confined. Now, under Part C, it deals with the defendant did so with the intent, and I would put forward that there is proof to say that the intent was to terrorize the child. The proof that you heard is that the child was left tied up alone in a basement with a sock over his eyes for some period of time. The medical proof would indicate that he was tied up for long enough time to cause those blisters that you heard testimony about on the ends of his fingertips. So terrorize and substantial bodily injury are 2 separate elements in both aggravated kidnapping and aggravated child abuse. So there are elements that do not overlap. In relation to the thought that this grandmother could have consent and would be fine to tie up a child, first of all, I don't think as a grandmother that she can legally stand in the position of the parents. But should the court consider that theory,
I'd like to point out that we're not dealing with a kidnapping charge. We're dealing with an aggravated kidnapping charge. So in State v. Goodman, which is 90 Southwest 3rd, 557, a 2002 case from the Supreme Court, we deal with whether or not a parent can be charged, and they can be charged. In this case, they're looking at the events of especially aggravated kidnapping, because you have these additional elements. Even if a parent can pick up their child and take them to bed, a place that they don't want to go, a parent cannot tie up their child and leave them in the basement long enough for them to have rope burns, significant burns that take months to heal. That is not within parental authority. That is child abuse, whether by a parent or grandparent, and that is aggravated kidnapping under the statute. So I submit that there is more than enough evidence to send this case to a jury.
This court has listened very carefully to the evidence in the case. The young man's testimony, Junior's testimony, was clear that his grandmother, the defendant in this case, was the one who tied him to a chair, that she tied him twice. And one time it was loose and he was able to wiggle free. The second time it was tight. That testimony is substantiated and corroborated by the medical proof, which indicates that there was a bruise of a slightly older age that was not as severe on the upper portion of the young man's arm. And then there was a more severe bruise that would have resulted from a tighter restraint. And in fact, it was a cutting injury that resulted. And that as again substantiates and corroborates the young man's testimony. He testified both as his testimony in this proceeding yesterday, as well as the court listened to the testimony that he gave, or the statement that he gave to the child advocacy worker, in which he clearly identified that it was his grandmother who had tied him to a chair. Those two elements together clearly indicate to me that there is sufficient proof to show that this case should go to the jury regarding the charge of aggravated child abuse. In addition to that, the injuries that were sustained are severe enough that they've left permanent scarring, and for that reason, the court finds that the elements of aggravated child abuse have been shown sufficient to allow the case to go to the jury. In addition to that, then the charge of aggravated kidnapping, again, as the state has pointed out, the charge of aggravated kidnapping requires the elements that the defendant knowingly removed or confined another unlawfully, so as to interfere substantially with the other's liberty, and that the alleged victim suffered bodily injury during the removal or confinement. A removal or confinement is unlawful if it is accomplished by force, threat, or fraud, or in the case of a person under the age of 13, if it's accomplished without the consent of a parent, guardian, or other person. Those are separate elements or separate definition. It does not mean that a person who is a guardian or a parent cannot be found guilty of aggravated kidnapping if they do something that meets the other elements. It means that it can either be by unlawfully, a confinement that is unlawful by use of force, threat, or fraud, or it can be done if it's below the age of 13, accomplished without the consent of a parent or guardian. I am of the opinion that in this case, while she might have been in loco parentis, so to speak, of this child by having been given the opportunity to care for the child, that the confinement by tying a child to a chair, which is what in the basement of a house, which is what is being alleged here and being at least brought forth by the testimony of the child, both in the statement that he made here in court and in the statement he gave to the child advocacy, that would be an unlawful confinement. It is far different than the argument that the defense makes about someone putting a child into a car restraint device is somehow going to be guilty of aggravated kidnapping. Unlawful is the key element of that. And unlawful means that it's accomplished by force, and by force means that I don't know how it could be any less forceful than to tie someone to a chair so severely that you leave cuts in the wrists of that individual that leave permanent injuries and permanent confinement. In addition to that, the substantial injury, all you had to do was watch the video of the child advocacy statement in that the child who is left-handed by the testimony could not use his left hand. His left hand was obviously affected, and he was not able to use it in a different way. And in my opinion, that testimony or that demonstrative proof, along with the medical proof, substantiates that there was a significant and serious bodily injury sustained, and therefore the motion to, I'm treating it as a motion for judgment of acquittal or a motion to dismiss, but in either event, the motion is denied. We are then ready to present. We have time for one witness.
Probably, Judge, I was going to have one point about the jury instructions,
All right.
real quick. So on page 9, and on the aggravated kidnapping, the indictment alleges with intent to inflict serious bodily injury or to terrorize. And I would like to elect to go with the to terrorize person. So we would need to switch out that number 2 to the, and the defendant did so with the intent to terrorize the alleged victim.
All right. And you're referring to on page 9?
Page 9, element 2 at the top of the page.
That the alleged victim suffered bodily injury during removal or confinement. You want to say that it was done in such a manner as to...
Well, actually, no, I'm sorry. I stated that wrong. I got mixed up. Yes, I would like to say that the defendant did so with the intent to terrorize.
All right.
And there were multiple parts listed in the indictment. So Ms. McKinney's charge was correct. I am electing to go with a different portion of that charge. And I have.
All right. The indictment alleges both serious, with the intent to inflict serious bodily injury or to terrorize. So therefore, that's what I'm going to instruct the jury, would it not? Why would we not include both, since that's what the indictment says?
Because there are alternate theories, and so that it is alleging a separate, I think I need to elect which one of those theories. And so I'm electing to terrorize.
You're electing to terrorize.
Yes.
The state's option, then we'll make that change. We will eliminate that the alleged victim suffered bodily injuries as a result of the confinement. I'm sorry, this is aggravated. I'm looking at the wrong, you're looking at, that is the aggravated kidnapping charge on page 9. All right, we'll make that change, and you'll be electing only to that the kidnapping or the restraint of the victim in the case was done so with the intent to terrorize. All right.
Lawful. Page 9, although the law requires.
Turn your microphone on, please.
In the pattern jury instruction, there is an optional instruction regarding to find the defendant guilty of the offense, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than necessary to commit the offenses or offenses. We would ask that that also be included from the pattern jury instructions. That plus 3 subsections. Add into subsections A through F.
Same thing you got. That's the
This
correct
was in
thing.
2020.
Well, the language that you've asked to be included would, the pattern jury instructions that were enforced at the time of the commission of this offense, alleged commission of the offense, says that it's to be included only if another offense against a person was committed during the alleged aggravated kidnapping as to that same victim is charged in the indictment and submitted to the jury. So theoretically, we have the charge of aggravated child abuse. So the charge would then have to state, to find the defendant guilty of this offense, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offense of aggravated child abuse as charged in count 1. In making this determination, you consider all of the relevant facts and circumstances of the case, including but not limited to the following factors. And then it would go forward with those factors. Any response from the state?
No, Judge, I don't object to the inclusion or the exclusion. I think the pattern instructions that were.
Well, we'll grant Mr. Bellmeyer's motion to include the charge, the additional language of that. Did you understand how I was reading it? It would be, okay. Give me a moment. All right. I wanted to make sure I was correct about that, and I believe that we are correct, that we're going to allow the inclusion of that additional language that Mr. Bellmeyers has asked for.
On what proof? Depending on what proof we ultimately put in, we may ask for a necessity charge.
For what?
Necessity charge. I know Ms. McKinney works on these quite a bit, so while we're in it, I would just go ahead and mention that. At this point, I don't think I can ask for it. It depends on how our proof comes out in the defense. I may ask for a necessity charge.
A necessity charge. You're saying a necessity that the actions were necessary?
Yes, Your Honor.
All right.
I believe it's 40.05. Like I said, at this point, I can't ask for it, but I know Ms. McKinney's already working on it, so I thought for the purpose of economy.
That's fine. You have a short witness that we can get in the next 40 minutes?
Absolutely. Yes, sir.
All right. And we're ready for the jury. Bring the jury back. All right, ladies and gentlemen, we are ready. I believe the state has rested their proof. Mr. Bellmeyers, do you wish to offer any proof of your own?
Yes, Your Honor, I'd ask to call Ms. Nedra Patterson.
Good afternoon, ma'am. If you'll come around, please, and follow our bailiff's instructions, raise your right hand and be placed under oath. Mr. Bellmeyers?
Would you state your name for the record, please, ma'am?
Nedra Patterson.
And would you please spell that for the court reporter?
First name Nedra, Nedra. Last name Patterson, Patterson.
And Ms. Patterson, do you know Patricia Kelley?
Yes,
And how do you know her?
she's my neighbor.
And in summer of 2020, did you live, were you her neighbor at that time?
I lived with my parents, they lived on the other side of her.
And so now you live on the opposite side of Ms. Kelly's house, but back then you were also her neighbor.
Yes,
Okay. And when you say your parents, they raised you, but they're not your biological parents.
they're not my biological, they took care of me when I was a teenager.
And so back in May of 2022, or the summer, May to August, you were there living with them.
In May of 2020, I lived with them, yes.
Thank you. And during that summer, did you see children living with Miss Kelley, small
Yes, I did.
children? And did you know them to be Junior and Jeremiah?
Yes,
And they were her grandsons.
yes.
Did you have interaction with them?
I said hi to them when I was, because I can't move there to take care of my parents and I mowed their lawns. So when I was outside doing yard work, we'd talk when they were outside, yes.
So you'd see them outside from time to time and just kind of
Yes.
friendly conversation and that was.
Yes.
Did you ever observe anything that summer that caused you any concern regarding their safety or welfare?
No, sir.
And had you saw anything that worried you about their welfare, or,
Absolutely not.
or they had been abused, would you have done something?
I would have called the police if I saw that they were abused.
Mr. and Miss Mathers, like you said, you've known them a long time.
I've known them for a long time.
And are they the kind of people, if they had saw something concerning, would they have called the police?
Absolutely.
Did you see the children the day they were leaving?
Yes, I did. I waved at them as they were leaving.
Okay, do you remember what you were doing that day?
I was out, probably just doing stuff in the yard or just sitting on the front porch having coffee. I don't remember exactly what I was doing that day.
Okay. I mean, did you hear any kind of commotion or anything going on over at the home that day?
No,
And did you ever see Raynell Sr., the boy's father, come to visit during the summer?
I did not see him come and visit.
But to be fair, I mean, you wouldn't have seen all the time, so he could have
No.
came in. But
Yes, he could have, but I didn't see it.
And do you know how long before the children left the home, the last time that you had one-on-one or close contact with the children?
I saw them just a few days prior to them leaving. They came over, Patricia and Levi, her son, and the two boys came over into the house, my parents' house, and we were talking and everything. We were laughing and cutting up and playing with the boys.
Did you see open wounds on the children at that time?
No,
Gashes on the back of their hands or rings around their wrist?
no.
Pass the witness, Your Honor.
General Bryson?
Ms. Patterson, so how long had you lived beside her?
I was with my parents from May of 2020 until they moved to Georgia, which actually I moved to the property over on the other side before they moved to Georgia.
And how many days before they left did you say the kids came over and were playing?
They didn't, what are you talking about, my parents or the children?
Are you saying the children came over and played at the house?
Just if, I'm gonna guess a couple of days.
Okay.
Patricia brought them over, we visited with them, played with the boys, had interaction. There was nothing on them that I saw.
Okay, so I want to go back to the time frame. What, if anything, helps you remember that it was just a few days before they left?
Just recollection.
Okay. And how long do you think they were at your house?
That day, they were there for a couple of hours.
And when you say are you saying you got down and played with them on the floor?
No, they came over to the chair and we talked and played.
Okay. What were they playing?
Just talking, playing, goofing off. They interacted with the dog, my parents' dog that was there, and just with my dad and my mom.
What were the kids' dispositions?
They were happy.
Okay. Do they run around? Are they crazy like normal kids? Like, did you have to get on to them at all?
No.
And the day that they left, you said you were out in the yard. Do you remember any more about where you were?
I was outside. The porch faces, and usually when Patricia would leave or come in, if I was outside, I'd walk over and say hi and talk to her, converse.
And did you go over to the children to say bye?
No.
So you waved at them as they left. That's your testimony, right?
Mm-hmm.
Were they in a car when you waved at them, or were they loading? What were they doing?
They were loading in the car.
Okay. And how far would you say it is between your house and Miss Kelley's house?
How would I say from her house?
How far?
How far? I would say probably from here to out in the hall.
1 second.
Anything further? Okay. Redirect?
No, Your Honor.
Thank you, ma'am. You may step down, you may leave, or you may have a seat in the courtroom. You have another witness we can take up in the next 30 minutes?
No, Your Honor.
All right, ladies and gentlemen, at this point, we have some of the parties in this case, participants in this case, have obligations that they're required to attend to this evening that we're not going to be able to go later than about 4:30. We don't have a shorter witness, so we're going to conclude, this case will conclude tomorrow morning, and you will begin your deliberations tomorrow, and I will give you the final set of instructions. We've been working on that during the time you've been across the hall, trying to make sure it was correct. So if you will remember the instructions that I've given you when you go home tonight, don't think about this case, don't try to hypothesize about it, don't do any research about it, don't talk about it to anyone until you come back tomorrow, and then when you've heard all of the proof and the closing arguments of the lawyers, I will give you a last set of instructions, and then you'll be the alternates will be allowed to leave, whoever that might choose to be, who that might turn out to be, and then you'll begin your deliberations. So we'll send you home tonight with our thanks and with those instructions. You're free to go. All right, just for our information, you have one more witness, is that correct? Do you know, Mr. Bellmeyers?
Yeah, at this point, Your Honor, we're going to consider whether Ms. Kelley will testify or not.
All right, well, I'm not requiring you to make that decision now, but I'm just trying to, we should be able to conclude this matter before lunch tomorrow and then let the jury begin deliberation. All right, then we stand adjourned till tomorrow morning at 9 o'clock.